Hey, everybody, welcome. Welcome to the Law of Self-Defense live show for April 11th, 2022. Come on in, folks. Make yourselves comfortable. Mark, David, glad to see you here. Let me take care of that. Looks like I am, in fact, broadcasting live, which is always good. Come on in, folks. Make yourselves comfortable. We should have a kind of lengthy show this morning with the closing arguments of the Michael Barisone attempted murder trial, what I've come to call now the Michael Witch Shooter, which is in Witch on a Broom, Witch Shooter Barisone attempted murder trial. We have, of course, been commenting on this case, throughout the course of last week for sure. Now we're at closing arguments, wrapping up the end points of today's proceedings. And presumably today, the jury will also be instructed and go into deliberations. So a quick refresher for everybody's recollection as more people come in and find their seats, of course. Glad to have you here, everybody. So this is the attempted murder trial of Michael Barisone in New Jersey. Michael Barisone is a horse trainer in the sport/art of dressage, a very, to the untrained eye, I'm not a horse person, a funny way of making a horse walk. But nevertheless, it's an Olympic level activity. Michael Barisone himself was a Olympic level athlete in this sport. And now older in life, in his 50s, I believe, he's now a trainer of others who want to be Olympic level dressage competitors. One of the people, and he's got a horse farm in New Jersey for the purpose of training people and horses in the sport of dressage. And one of the people interested in taking instruction from Michael Barisone was Lauren Kennerak. Lauren Kennerak in her 40s at the time all this happened, but nevertheless, apparently with aspirations of being an Olympic level dressage competitor, solicited Michael Barisone for instruction. He invited her to live on his horse farm to house her horses there. Apparently, this is not an unusual thing. She brought her boyfriend, Robert Goodwin, with her. And almost immediately, the relationship between Michael Barisone on the one hand and Lauren Kennerak and Robert Goodwin on the other became extremely toxic, unbelievably toxic. She appears to have set out to destroy Michael Barisone emotionally, psychologically, professionally, societally, reputationally, quite intentionally. She said the most vile things you can imagine about him on social media, often, repeatedly, at length. And she has no qualms about any of the bad stuff she said about him. As far as Lauren Kennerak appears to be concerned, social media is for shit posting. And so she was shit posting Michael Barisone, with whom she had disagreement. Barisone himself appears to have been, although he presented apparently as a very confident, tall, strong man, he apparently was extremely emotionally fragile. He had a history of abuse back to childhood, and he was a unfortunately vulnerable victim to this kind of apparent bullying and emotional torture by Lauren Kennerak and her boyfriend, Robert Goodwin, to the point where it would appear that Michael Barisone, in fact, broke mentally, broke emotionally. Now, he tried repeatedly, he asked repeatedly for Lauren Kennerak to leave his property, but he had invited her to live there. That makes her a tenant. She has rights as a tenant. You can't simply throw a tenant out of their home. And it wasn't until the day before the culminating events here, which involved an alleged attempted murder by Michael Barisone, it wasn't until the day before that he actually showed her an eviction order, and that eviction order was apparently a ruse. His own lawyer, Michael Barisone's own lawyer, who drafted that eviction order, did not, in fact, file it in court. They were simply trying to scare Lauren Kennerak into believing the eviction process was underway to encourage her to depart. In any case, in the culminating day of this event, Michael Barisone had been just notified that Lauren Kennerak was accusing Michael Barisone of sexually inappropriate behavior with Barisone's girlfriend's daughter, teenage daughter, and Child Protective Services had been called with Lauren Kennerak's claim. By the way, the claim appears to be completely fabricated and fake. There's no evidence I've seen to support anything of the sort. It was just another act of torture by Lauren Kennerak towards Michael Barisone, but apparently that was enough to finally break him. Barisone approached the boyfriend, Robert Goodwin, and said, "Hey, can't we settle this? I don't want us to have a war." And Goodwin said, "Listen, it's too late. The lawyers are already involved. Let's let the lawyers settle this." Goodwin walked away from Michael Barisone, and Lauren Canarac walked past Goodwin towards Michael Barisone, saying, who knows what, presumably more vile things. At which point, Michael Barisone, according to the state, pulled a pistol, shot Lauren Canarac twice in the chest. That she was shot twice in the chest is indisputable, and then fired a shot at Robert Goodwin, the boyfriend, who was on his way back into their home. Missed Robert Goodwin, struck a window with the round, however, shattered the window, at which point, according to the state and the victims here, Lauren Canarac and Robert Goodwin, they physically delivered a beatdown to Michael Barisone, they would say, to prevent from being shot by him again. So Michael Barisone did end up suffering a physical beating. He was bit by the couple's dog, Rosie. So he had dog bite injuries as well. Michael Barisone himself says within moments prior to whatever the shooting was, until he came to in the ambulance on the way to the hospital, he has no actual recollection of what happened. So he has no recollection of firing the shots. He has no recollection of the beating. He has no recollection of any of the key events here. And of course, the only witnesses are Michael Barisone, hardly a witness since he says he can't remember anything, and the victims of his purported use of force, Lauren Canarac and Robert Goodwin. And of course, Canarac and Goodwin are going to say it was Michael Barisone at fault. So because he shot Lauren Canarac twice, the state believes, and shot at Robert Goodwin, Michael Barisone's been charged with 2 counts of attempted murder. And this is New Jersey, so of course he's facing a gun charge as well, because he wasn't in lawful possession of the gun he used purportedly to fire the shots. By the way, he was offered a plea deal early on for 10 years in prison, and he declined that plea deal, which now looks a little foolish because he really has no defense against the gun charge. I mean, listen, I believe all these gun laws are facially unconstitutional. I think all gun laws preemptively applied to law-abiding, mentally sound American citizens are unconstitutional, period. But New Jersey disagrees, and they will enforce their gun laws. So they are fully prepared to put Michael Barisone in jail for 10 years on the gun charge alone. And he really has no defense. I mean, it's a possession offense, and he was in possession of the gun. It seems indisputable. So he was looking at 10 years minimum, regardless, effectively, on the gun charge. He could have taken that 10-year hit and had basically the attempted murder charges go away. Well, he would have been convicted, but he would have had no more prison time. And now he's looking at, well, whatever the sentence will be for attempted murder, which generally an attempt crime, the sentence is the same as the underlying crime. You don't get a break for failing in your attempt. So he could be spending it the rest of his life in prison if he's convicted of these attempted murder charges. So in hindsight, maybe not a good idea not to have taken that plea, especially on the facts of this case where the defendant himself says he can't really remember what happened. A little awkward. So let's take a moment to talk about the defenses here, the theoretical defenses. There's a number of possible defenses here. There are 2 perfect defenses. By perfect defenses, I mean defenses that, if believed by the jury, would lead to an acquittal, 0 criminal liability. These are in theory 2 perfect defenses. One of those is self-defense, that he shot Lauren Canarac and shot at Robert Goodwin in justified self-defense. Of course, a claim of self-defense requires the 5 elements of self-defense, especially under New Jersey law. Those are innocence, imminence, proportionality, avoidance, and reasonableness. And to defeat that claim of self-defense, the state has to disprove beyond a reasonable doubt any one or more of those elements. The difficulty for self-defense here is that there may be nothing to defeat. I mean, there has to be some prima facie evidence on each of those elements before self-defense can be raised as a legal defense in the first place. You can't just fabricate it out of thin air. There has to be some evidentiary basis to support self-defense, and there doesn't appear to be. Remember, the only other witnesses besides Barisone were Canarac and Goodwin, and Barisone says he can't remember anything. So where's the evidence of self-defense? That's not speculative. And if it's a merely speculative claim, it's not a legal defense at all. And therefore, there's nothing that the state would have to disprove on self-defense. So self-defense doesn't look great here. The second perfect defense that would lead to an acquittal, zero criminal liability, would be insanity. The insanity defense, however, is a very high threshold. Effectively, Barisone would have had to not known he was shooting at human beings. He would have had to believe he was shooting at Martians or robots or werewolves or maybe a witch. And I've seen no evidence in this trial to suggest that was the case, that he was so detached from reality. He so much didn't know what he was doing was wrong. He didn't know right from wrong. He didn't know he was shooting a person. I just haven't seen any evidence that even approaches that in this trial. But even if insanity were believed by the jury and resulted in an acquittal, not guilty by reason of insanity, that doesn't mean Barisone would be freed. It means he would be institutionalized for some indeterminate period of time, not released until his doctors determined he was safe for society, which could be in weeks or months or years or theoretically never. But again, insanity does not look like a very robust defense here. So those are the two perfect defenses that could lead to an acquittal, zero criminal liability, and neither one of them looks very good here. In fact, in the opening statement by the defense, way back when, and we covered that as well, the defense counsel, Edward Belinkus, spent maybe 95% of his opening, 45 minutes long opening statement, talking about stuff that theoretically would be applicable to an insanity defense, and only 5% that would be applicable to self-defense. And again, neither of those perfect defenses seems very robust. Now, there are also imperfect defenses here. Imperfect defenses are defenses that would not lead to an acquittal. You can't get to zero criminal liability with an imperfect defense, but you could mitigate what would have been murder to manslaughter, or in this case, what would have been attempted murder to attempted manslaughter. And that's possible here. So there's two closely related imperfect defenses that could be raised here. If it's a Venn diagram, it's almost a circle. One is imperfect self-defense. So we could imagine, for example, that Barisone genuinely believed that he needed to shoot Lauren Kennerak in self-defense. Apparently, he had delusions that she was a physical danger to him. But that subjective belief was not was not objectively reasonable, because the element of reasonableness in self-defense requires both subjective and objective reasonableness. You have to have had a genuine good faith subjective belief in the need to use that force in self-defense, and that belief would have to be of a nature that a theoretical, reasonable, and prudent person would have shared that belief. It has to be subjectively genuine and objectively reasonable. If you're missing the objective reasonableness, you've lost the element of reasonableness needed for perfect self-defense, and you don't have perfect self-defense, so you can't get to an acquittal on self-defense. But if the only defect in your claim of self-defense is that you had that subjective belief, but it was objectively unreasonable, so you fail reasonableness, but that's the only defect in your claim of self-defense, you might qualify for imperfect self-defense, which doesn't get you to an acquittal, but would mitigate murder to manslaughter, or here, attempted murder to attempted manslaughter. Another imperfect self-defense possible here, closely related to imperfect self-defense, is one of diminished capacity. And there the idea would be that the torture to which Lauren Kennerak and Robert Goodwin had put Michael Barisone had so broken him mentally that he actually lacked the capacity to form the intent necessary for murder. And under that diminished capacity, the law allows for, the mitigation of what would have been murder or attempted murder to manslaughter or attempted manslaughter. And frankly, I think that's probably the most viable defense here. That diminished capacity defense, based on how unhesitatingly Lauren Kennerak concedes to the torture, especially through social media, the unbelievable, horrible things that she said, apparently largely untrue, about Michael Barisone, simply in an effort to bully and torture him. She just didn't like him. That's why she did it. Now, that makes her a horrible person, some would say, perhaps even a witch in the colloquial sense, but it's not grounds for shooting her under the law. No matter how emotionally satisfying that notion may be, it's not legally grounds for using deadly defensive force by Michael Barisone upon Lauren Kennerak or Robert Goodwin. So it can't be a perfect defense, but it might contribute to that diminished capacity, particularly since the driver of the diminished capacity were the victims themselves. So it wasn't like some third party was destroying Michael Barisone's mental and psychological health, it were the people that he used force against, and they did it intentionally. So I think that's probably the most viable defense here. Such a mitigation verdict by the jury in this case would not surprise me at all. Attempted manslaughter as opposed to attempted murder. And then we have the fourth, well, it's not really a defense, it's more a wish. And the wish is that the way the victims here, Lauren Canarak and Robert Goodwin, presented themselves in court in front of this jury, just make them look so monstrous and horrible that the jury dislikes them so much and has so much sympathy for Michael Barisone that they'll simply either acquit or mitigate his offense based purely on that. But that's not really a legal argument, that's an emotional argument. So I have ready to go, ready to roll, and the closing arguments now in the courtroom. It did start earlier in the day, so we're probably a couple of hours delayed at this point, but if you wanted to watch it straight, you should have been there on time. If you want my commentary and analysis, this is the place to be. I haven't listened to it, so I'm as naive to these closing arguments as all of you. I did note that the closing arguments appear to jump right into the defense closing, which is odd. So the way it would normally work is the state gives its closing argument first, and this is the opportunity for the state to kind of wrap up all the testimony evidence that's been shown to the jury over the course of the trial and wrap it up into a coherent narrative of guilt, the story of guilt for the jury to consider. So normally the state would go first, and then the defense would present its closing argument, presumably an attempt at a coherent narrative of not guilt, and then the state would get a rebuttal. And it looks almost like the state here, on quick glance, we'll see what happens, but it looks almost like the state said, Your Honor, we'll pass on our closing, we'll cover everything in our rebuttal, so let the defense go first, which would be unusual, but arguably maybe appropriate here, because this is really what the state, I mean, there's no contesting really that Michael Barisone shot Lauren Canarak at Goodwin. What the state has to worry about is not so much, like in a traditional self-defense case, it's not so much the underlying physical conduct that's at issue, it's whether or not it was justified or excused in some way. That, of course, will be raised by the defense in their closing, and that's what the state really has to counter. So it may be that the state is holding onto its ammunition until they have the opportunity to bring it to fire to counter the defense arguments on closing. So I know there was a jury charge conference on Friday. Sorry, I had other obligations, so I didn't watch it. That's when the outside the hearing of the jury, the judge and the parties argue about what the final jury instructions should be. We'll just see what they are here. After the closing arguments, the judge will instruct the jury, and then we'll go. And we'll have some insight into that. We'll have some insight into that by what the parties choose to address on closing. Obviously, they know what the final jury instructions are, so what they don't talk about either is not helpful to them or not in the final jury instructions. As always, folks, if you're watching this on our Law Self-Defense members page, because you're a Law Self-Defense members, that's what I encourage members to do, because we'll look at the questions there. Let me make sure that's in fact working the way it's supposed to be. There's a chat function in the Law of Self-Defense members dashboard area where this is being broadcast live, and we prioritize those questions. So we promise to answer those questions first. Let's see, that was the wrong button. Hey, David's there in the chat. So great, we're live in the Law of Self-Defense members page. We should also be live on Rumble, although I have to confess I'm not 100% sure how Rumble actually works, but if I see a Rumble rant, I'll answer questions there. If you're watching on YouTube, which is almost all of you watching this live, then if you'd like your question answered, it has to be in the form of a super chat. Otherwise, I just can't find it among the hundreds of other comments that are in the chat. So make it super chat. It gets bolded for me. It's easy for me to pick out. In fact, I'm going to go ahead and play the little intro video to today's content, and then I'll answer whatever super chat or other questions have come in already, and then we'll dive into the substantive content of today's show. So here we go with that intro. All right, that is that. I should also, of course, mention the sponsor of today's content, which is, as usual, CCW Safe. CCW Safe is a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members' legal expenses if the member's involved in a use of force event. And those expenses start big and get bigger fast, folks. In a killing case like this, or rather an attempted killing case, murder or manslaughter, it's not unusual to burn through a couple $100,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family against criminal predation, it can be useful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought, as if the rest of your life depends on it, because really it does. And we'd all like to think we live in a world where how much money, how many resources you can bring to the legal battle don't matter in terms of the justice you get, but I can assure you it matters just like anything else in life. So I've looked at all the companies that offer this kind of service, as you might imagine, and I have found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide. And they're not the best fit for everybody, folks. Every one of these companies has different exclusions and conditions. For example, CCW Safe does not cover domestic violence situations. So if you're at risk of domestic violence, this would not be the plan for you. And they tell you that up front. If you're not at risk of domestic violence, well, then it might well be a good fit for you, just as it is for me. I do, however, urge you to take a look at what they have to offer so you can make an informed decision about that fit. And you can do that at lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off the first year of your membership by using the discount code LOSD10, LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCWSafe. I also want to mention our new series of absolutely 100% free webinars that we're holding over the course of the month of April and May. April's just about half over at this point, actually. We're calling these our Hard to Convict webinars. In these webinars, and again, they're 100% free, we show you how to transform yourself from being easy to convict if you're compelled to defend yourself, your family, or your property, to being hard to convict. As part of that, we cover, we bust some of the most common myths of self-defense law, things that people believe to be true because they've been told it 100 times or 1,000 times, or seen it on the internet or in a gun magazine, or their retired cop neighbor told them this was the law, and they're all wrong. All those myths are wrong. In fact, they're worse than wrong. They're damaging. They make you easy to convict. If followed, they are a quick path to a lengthy prison term. So we don't want you to do that. We don't want you to be easy to convict. We want you to be hard to convict. And as part of that mission, we're holding these 100% free hard to convict webinars to bust those myths of self-defense. Now, again, 100% free, but each webinar is limited to 100 people, 100 seats each, folks. That's so I can adequately handle the live Q&A we do at the latter portion of each of these webinars. They last just under 2 hours typically. And we have a bunch of these scheduled over the months of April and May. If you're interested, I would encourage you to sign up. Please sign up only for one. They're all the same, and we don't want you to take multiple seats. It's not like they're a series, 1, 2, 3, 4. They're basically all the same webinars. You can sign up for your seat there at lawofselfdefense.com/hard-to-convict. Doesn't cost anything, but you do need to register so we can count up to that 100-seat limit for each of these. And they are filling up super fast, folks. As they fill up, the dates come off that web page there, and new dates will be displayed. So if you see a date, it's still available, but it may not be there the next time you look because it might have filled up. Again, that's lawofselfdefense.com/hard-to-convict. Easy enough to remember. And let me take a look and see if there are questions already in place from Law of Self-Defense members. Not yet. David's there. Thank you, David. David's always there, it seems like. Always nice to have our most reliable Law of Self-Defense members there during our live shows. We also have Rumble. No Rumble chats yet, which is not surprising. We often don't get Rumble chats. And in terms of super chats, let's see. Well, I know one came in. Come on, YouTube. It's only showing me ones from last week. Here we go. TH, thank you for your super chat contribution. Writes, I watched them go over the instructions Friday. His defense attorneys declined anything with diminished capacity, from what I understand. They are convinced it's self-defense. Well, thank you, TH. As I say, I did not watch the charge conference, the jury charge conference. I know some of this terminology gets confusing. The judge charges the jury. It doesn't mean the same thing as charging someone with a crime. It just means he's instructing the jury. In that context, charge has a different meaning than it normally does. So the judge charges the jury with the instructions. The judge instructs the jury on the law. In the charge conference or the instruction conference, the parties argue about what instructions they want and don't want, by the way. And the defense can not want a mitigation charge like imperfect self-defense or diminished capacity. They may decide to just go for it. Either it's guilty or it's a perfect defense. So either it's guilty or not guilty, period. Nothing in the middle. And they may do that if they believe, they're confident that a jury won't come back with a guilty verdict. And they don't want to risk that the jury might otherwise go for something in the middle, go for a compromise verdict, go for a mitigation verdict. Because, a mitigation verdict here is still 10 to 20 years in prison. Possibility of parole. So, it varies a lot by state, how much of the underlying sentence you have to serve before you're eligible for parole. Some states, it's about a third. Some states, it's 85%. So it really depends. My expertise is not sentencing law, so I'm not sure exactly what the criteria is in New Jersey, but it would be prison time, and an acquittal would not. A perfect defense, if accepted by the jury, would not. So it's possible the defense here is saying, hey, we're just going for it. That's a high risk path, of course, because the jury may not be comfortable going with an acquittal. After all, someone who appears to be a 105-pound woman was shot twice in the chest, and another person was shot at. And the justification for that shooting appears sketchy as heck, especially when the shooter himself claims he doesn't have a memory of what happened. So pretty hard I would think, for a jury to swallow that should be an acquittal. On the other hand, the woman was kind of a witch by all appearances. So maybe they feel she kind of earned it. I mean, juries are human, right? So those emotional arguments can have an effect. All right, so that's all the super chats. Let me jump over now to the tab with the actual closing and see what's going on. We're going to be starting at the beginning. So again, we're a couple of hours behind. That is not the one I want. Let's see. This is the one I want. So let me pull that up. Here we go. Here we are. This is the start of the stream. And I may, if there are slow spots, again, I haven't seen this myself either. So I'm as naive to this content, this video content, as you are. We'll both be going through it at the same time. If there appear to be long pauses, I'll try to jump ahead to keep things moving along in a timely and reasonable fashion. Okay, let's see.
I don't see any reason to change the model charge. I think it's clear. Telling the jury you can draw an inference.
And then, Your Honor, one area that I think you're going to agree needs to be addressed is we need a better charge language on the preponderance standard. Because that's your initial charge on the burden and standards of evidence. You talk about reasonable doubt, but there's a very important shift.
All right, so he's talking about preponderance. That means he's talking about insanity defense. So they haven't said the words insanity defense yet, but that's the only legal defense to which preponderance would apply. If they raise a claim of self-defense, the state has to disprove self-defense beyond a reasonable doubt. And the state has to prove the elements of the crime beyond a reasonable doubt. If they raise a claim of insanity under New Jersey law, the state has to disprove insanity. Sorry, the defense has to prove insanity by a preponderance of the evidence, meaning a sheer majority of the evidence, 51% of the evidence. The state doesn't have to disprove insanity. The defense has to prove insanity by 51%. That's the preponderance here. And apparently the defense is not happy. And this is co-counsel here. The gentleman sitting on the left with the red tie, that's Edward Blinkus. He's been the lead counsel. He's done almost the entire trial himself. Only on rare occasions has co-counsel done much of anything. In fact, I don't even know co-counsel's name. But here, co-counsel is the one arguing with the judge about the instructions. They're still finalizing instructions moments before closing argument, which is always unfortunate. This should all be done well beforehand. But he's arguing for some clearer language on a preponderance of the evidence, which is hard to understand because it's such a clear concept. There are legal standards that are somewhat ambiguous. I mean, beyond a reasonable doubt, what's that mean? We don't have a nice mathematical figure for that. It's not 90% or 95%. Anytime a trial judge tries to define beyond a reasonable doubt with a numerical figure, they get reversed on appeal. So we don't have a number for that. Another standard is clear and convincing evidence, which is somewhere between preponderance and beyond a reasonable doubt. But we don't have a nice mathematical figure for that either. At least with preponderance of the evidence, we have a nice mathematical figure. It's 51% or 50.1%, or it's something barely above midway. The preponderance or sheer majority of the evidence. It's a pretty simple concept to understand. So it's not clear to me how they could have screwed that up to the point that it still needs clarification moments before closing argument, but there we go.
In the standard which the jury must use to assess the insanity defense. It's a much lower standard of preponderance. And that's why I took the language mostly from the model jury charge, civil jury charge, charge number 1.1.
So he's referencing civil jury charges because preponderance of the evidence is the legal standard routinely used in civil cases. So if you sue someone civilly for some tort, for some damage they've caused you, or you're sued by them, the plaintiff has to prove their case not beyond a reasonable doubt, like a prosecutor has to do in criminal court. A plaintiff in a civil case has to prove their case by a preponderance of the evidence. So normally you don't find preponderance in a criminal case, except in the context of some unusual defenses like insanity defense. Traditional affirmative defenses are often have to be proved by the defense by a preponderance of the evidence. You normally see preponderance in civil cases. Here, of course, we're in a criminal case dealing with insanity defense, which has a preponderance standard. And because it's unusual in the criminal context, they're citing civil law to get a definition of preponderance.
1.2i, and I submitted a red line version so people could see the model language and the language that I proposed to put this into your charge on the insanity defense.
Mr. Shellhorn, what's your position?
Judge, the model charge was adopted, I think, in 1988, if I'm not inaccurate about that, about the insanity.
Hey, for those of you suggesting my microphone was not working correctly, you're right. It looks like the setting was incorrect. Hopefully it's better now. Before you might have been getting the audio from my computer's internal microphone as opposed to my fancy Joe Rogan microphone. Hopefully it's improved. Thanks, Shane, for bringing that to my attention. I appreciate it. It should be fixed now, I think. Yeah, definitely. I can hear it in my own audio. All right. Sorry about that. Good thing that my claim is legal expertise and not audio or IT expertise.
Sanity, I don't know why there would be a need to start modifying it with this case. There's nothing unique about this case that will call for that.
I agree. The court's charges directly from the model charge on insanity, model criminal charge.
All right, so he mentions the model charge. Just about every state has standardized jury instructions now. They often call them model jury instructions. Back in the day, decades ago, there were no standard jury instructions. Jury instructions were drafted de novo for each trial based on legal precedent, case law, the facts of the case. Each side would draft their own jury instructions, drafted new for that trial, submit them to the judge. The judge would consider and come up with a final version. The trouble was, of course, with that model, that traditional model, was similarly situated criminal cases would end up with quite different jury instructions and quite different legal outcomes. And that seemed, reasonably enough, to be unfair. So what happened was the states began to standardize their jury instructions. Normally, that's a process that involves the state Supreme Court puts together a committee of experts, law professors, leaders in the legal community, judges, and they spend months arguing over what the perfect jury instructions should be for different kinds of cases, different kinds of criminal charges and legal defenses. And they come up with a standardized or model set of jury instructions approved by the state Supreme Court. And those are the ones you're supposed to use. And trial judges will stick to those pretty hard for good reason. Now, they're always modified a little bit for each trial because you have to modify them at least for the names of the defendant, for example, or particular facts of the case, like what weapon was used. You might modify, customize the jury instructions on those details. But trial judges don't like to substantively modify the model jury instructions because these are instructions the state Supreme Court has told them to use. And one of the quickest way for a trial judge to get reversed on appeal is to substantively use different jury instructions than his own state Supreme Court has told him to use. So when you see judges like this say, hey, we're just going to use the model jury instructions, that's what we should do. Hold on a minute, folks. All right, folks. So when you see a judge like this hearing arguments about jury instructions and he's got the model ones and they seem to apply and someone's arguing for changing those, very, very hesitant to alter the model jury instructions.
Well, Your Honor, just
As this is a criminal case, not a civil case, and I don't think your proposed charge is particularly neutral. Whereas the model charge is meant to be just that, neutral, especially as it pertains to the defense of insanity.
Your Honor, I think the fact that the charge hasn't been revised since 1988 is actually a fact to the detriment of its use as written, because what happens frequently with model charges is they don't keep pace with the developments in the law. So I again would advocate.
What's been the development in the law since the model charge was drafted as the preponderance of the evidence? I don't think that's changed since 1988, that the court has a new view of what preponderance of the evidence standard is.
I agree with you.
It's remained the same, and the charges remain the same.
I don't think that the actual law on what constitutes the preponderance of the evidence has changed, but I do believe that the language as written is inadequate to give a non-biased charge on what evidentiary standard the jury should use to decide the insanity defense.
I don't think there's any need for an alteration in the model charge, counsel. Thank you.
Thank you, Your Honor.
All right, you ready for summations?
Yes, Judge.
At the end of the summations, I'm not sure how long they're going to go. I'll decide whether or not I'll charge this morning or maybe break for an early lunch and then charge this afternoon. I'll make that decision after I hear summations.
Summation, of course, just means closing argument, and charging the jury just means reading the jury the agreed upon, or the judge. The judge decided whether the parties agreed or not. The judge decided jury instructions.
All right, let's bring the jury in.
I'm going to skip forward here.
Masks.
Alicia, we need more masks. Do you have another box?
Masks.
Yeah.
It's New Jersey, so of course they still have the magic plexiglass all over the courtroom to keep
You
COVID
got
from
copies of the charge, counsel?
Yes, Your Honor. Thank you.
whatever.
All right, we'll bring the jury in now, Kate. Thank you.
Oh, come on. So this is lead counsel now, Edward Belinkus.
Before I start, I'd like to thank you all for your service. The time spent, your attention is greatly appreciated. I know what a huge sacrifice it was for you to serve on this case. This is what makes this country great. This process that we've gone through is what distinguishes us from every other country in the world. It's been an honor and a pleasure to try this case.
By the way, folks, before we dive into the meat of the defense closing, and again, normally the state would close first, and then the defense, and then the state on rebuttal. So I don't know why the defense is going first here. I don't know. They must have some kind of agreement that was done. But this is the defendant here on the left, in the white shirt, the blue tie, the guy who looks crazy, right? That's the defendant. I just want to show you a quick, just a few seconds of video of him being interviewed just about a decade ago. In fact, almost, about a decade ago, to show you what he looked like before he underwent this experience with Lauren Canarak and Robert Goodwin. So to compare and contrast how different this guy was before he was subject to this torture by the quote unquote victims in this case. So I'm going to stop this, pull up another screen. I'm only going to play a few seconds of it, but I think there's no other way to drive home the impact, the negative impact these people had on him, other than to share this little bit of video with you. Let's see if I can find it here. Here it is. That's him, folks. That's Michael Barisone. And I'll play a few seconds of it just so you get a sense of the man.
For pre-Olympic training, and that sort of led to me. I knew Philip since Hong Kong. We went together on that. I was on the dressage team and him on the
6'3", big guy,
so sort of knew each
imposing,
other. But my
confident,
England trip
professional,
led to
Olympic champion,
helping
or at
prep,
least
and
Olympic level
Phillips, and
competitor.
he said, "Well, you watch Jenny." So that's kind of how it went.
Okay, and Silver says
Look
you're
at the
great
color of
because
his
you're
hair.
so positive, but it must be hard to switch gears a little bit and help with the event riders.
I don't think so. Horsemanship's horsemanship. Basics are basics, right? I mean, all that I tell.
All right, I don't want to dwell on that. I just wanted to share that with all of you, because certainly, I mean, I found the difference to be quite striking between that fellow and this fellow on the left. 10 years, folks.
The way this works, ladies and gentlemen, is that I sum up first. The prosecutor goes after me. I will not be able to comment or dispute anything that he says. As the judge told you, and I'm sure he'll tell you again, what the attorneys say is not evidence. Because I can't respond, I'm going to ask you to listen carefully to everything he says. Make sure the evidence supports what he says. Because if you remember in his opening statement, he told you when Michael Barisone drove down to the farmhouse and confronted Lauren Canarak, He was angry. He was furious. Those were his words. I submit there is no evidence whatsoever in this record to support that statement. To the contrary, it's the opposite. Even Robert Goodwin and Lauren Cataract described Michael Barisone as calm. He used the word sorrowful. It was the defense that brought out that Lauren Cataract was the one that was pissed. That's her word. She was the one that came stomping down to confront Michael Barisone. She's the one who described herself in her original statement as being Miss Badass. The same description of her conduct with an earlier altercation, where she got up into Michael Barisone's face. She pushed him back 20 feet or so. He tried to leave. She prevented him. Remember, she slammed his door shut. He was pleading with her to leave. Those were her words.
Remember, folks, what we're looking for here is, closing argument that's relevant to either one of the two perfect defenses, self-defense or insanity defense. And frankly, I don't expect much in the way of self-defense. It looks like they're going entirely insanity defense. Or closing argument that's consistent with some kind of diminished capacity, or she's a witch and had it coming, and you should acquit or at least mitigate my client's offense and resulting sentence, which of course will be up to the judge, not the jury, because of what a witch she was. That's what we're listening for in this closing. The last, again, is not really a legal argument. It's an emotional argument, but maybe that's largely what they have.
With respect to the law of insanity, the judge will instruct you. Again, I'd just like to...
And here we go, folks. This is the insanity defense, explicitly put forth by the defense on their closing argument.
Point out that the law recognizes that a forbidden act should not be punished criminally unless done with the knowledge of wrongdoing. If someone is found not guilty by reason of insanity, it does not mean that he will be freed or that he will be indefinitely committed to a mental institution. The court will hold hearings, make determinations as to whether, there are things to adequately protect that person, but more importantly, to protect the public. In my opening statement, I told you what I thought this case was about. Far different than as the prosecutor described it in his statement. After you've seen all the evidence, I hope you agree that it's not a simple cut and dry case as the prosecutor suggested. I submit, ladies and gentlemen, that the state has not met its burden. I submit you should find Michael Barisone not guilty.
Well, interestingly, if the defense is insanity defense, that's also, you've heard me probably speak before, that the defense of self-defense is a defense of confession and avoidance. It's not a defense, a traditional defense like alibi. Like, I wasn't there, it wasn't me. I was at my mother's house having dinner. She'll testify to that. You're saying the opposite of that. You're saying it was me. I shot that person, but I did it with the legal justification of self-defense. You're conceding to the underlying physical conduct. You're confessing to the underlying physical conduct, and you're seeking to avoid criminal liability on the grounds of justification, confession and avoidance. If you say it wasn't you, you can also argue self-defense, or strictly speaking, some courts will allow you to argue inconsistent defenses. But you think a jury buys that? You think a jury's going to buy, hey, it wasn't me, I was at my mother's house having dinner that night. But if you don't believe that one, it was self-defense. That just doesn't fly. It's logically incoherent. Can't have been both, right? And if you've shot someone, the jury generally wants to know why that was necessary. If it was necessary within legal boundaries, okay, well, the law allows for that. That's an acquittal on the grounds of self-defense. But if you can't explain to the jury why it's necessary, you just shot another person, and that's unlawful on its face, absent some justification or excuse. Well, insanity defense really is also a defense of confession and avoidance. You're confessing to the underlying physical conduct. Instead of a justification defense, you're raising an excuse defense. Insanity is an excuse defense. The difference, the law often doesn't make this distinction anymore in an explicit sense, but from an academic historical sense, there's a difference between justification defenses and excuse defenses. Justification defenses would be those in which the outcome was a social good. So a woman shoots a man and she says, yeah, I shot him, but he was in the process of raping me. Well, societally speaking, a dead rapist is better than a raped woman. So it's a societal good. The outcome of that equation is a societal good, arguably. An excuse defense is one where the outcome is not a desirable good. It's a bad outcome. So, for example, an insane person believes they see a Martian standing in a bus stop and they shoot the Martian, and it turns out to be a pediatric oncologist. Well, that's not a good outcome. We lost a child cancer doctor simply because the shooter was deluded. That's not an outcome we would ever choose. But we nevertheless excuse the shooter of criminal liability because of their insanity. So that's an excuse defense. Here, that's what's being argued, insanity as an excuse defense. But it's still the defense of confession and avoidance. You're confessing, you're not denying the underlying conduct. You're saying, yeah, I did it, but I did it under circumstances in which I was insane, didn't know right from wrong. Well, the burden on that is on the defense to prove insanity by a preponderance of the evidence. So when this defense attorney says, I suggest the state has not met its burden, the state has met its burden if you're raising the defense. The state's burden is to prove the underlying physical conduct. But if you're raising an affirmative defense like insanity defense, you're conceding the underlying physical conduct. So in fact, the state has met its burden. Now the question is, have you met your burden as the defense to prove insanity by a preponderance of the evidence?
Clearly, it's horrible that Lauren Cataract was shot. No person should have to go through that. It's important that you look at the evidence, though. And I submit to you, as I did in my opening statement, that the only evidence as to how the shooting occurred comes from both Cataract and Goodwin. The investigation starts and stops with them. It stops with Robert Goodwin pointing to Michael Barisone and saying he's the shooter.
Well, he was.
Two people who I had indicated in my opening, and I believe the evidence has confirmed, have a motive to lie, who have changed their stories, left important things out, important facts, and have now walked into this courtroom, put their hand on this Bible, looked you all in the eyes, and lied to you.
What would any of that have to do with whether or not his client was insane at the time he shot them? I don't know. Maybe he'll get to that. But so far, he's arguing that they're bad people. That doesn't mean his client didn't know right from wrong at the moment he shot them. Those are two completely different questions. Now, that they're bad people, he may be going for that emotional defense of, hey, they suck so bad, they're so mean that you should mitigate or acquit my client on that basis. But that's not an insanity defense. That's not arguing my client didn't know right from wrong at the moment he pulled that trigger. That's just arguing they're bad people. Oh, yeah, by the way, folks, if you can, please hit that subscribe button. If you look at that YouTube video, if you're watching on YouTube, as most of you are, and that subscribe button is red, you need to pound it like a steak in a circus tent. Just pound it. It was hard to think of a appropriate PG-friendly analogy there, but I know it wasn't very good. But if that button is red, you need to hit it, turn it gray. If you want to get notifications of our live shows, please hit that bell and choose the option that's appropriate for you, hopefully all notifications. If you could hit the like, thumbs up, and leave a comment, even if the comment is just your city and state, both of those things help fool the YouTube algorithm into spreading word of our content more broadly, helps us grow the law of self-defense community. And, that's kind of our mission, to reach ever more people with our transformational narrative of moving you from being easy to convict to being hard to convict. So hit subscribe, hit thumbs up, leave a comment. That's all greatly appreciated. Back to the show.
The judge is going to instruct you as to a legal concept. It's called false in one, false in all. If you believe that someone intentionally came into this courtroom and intentionally lied about a significant fact, you could disregard their entire testimony. I submit that that's exactly what you should do with Lauren Canarak and Robert Goodwin's testimony. Before I get into their specific testimony, I'd like to talk to you about the inadequate investigation that I mentioned in my opening statement.
All right. So anytime a defense attorney is talking about inadequate investigation, that's the argument you make when you have a guilty client. When you don't have the law or the facts on your side. You know the cliche. If the law is on your side, you pound the law. If the facts are on your side, you pound the facts. If neither the law nor the facts are on your side, you pound the table. Talking about the defective investigation is always pounding the table, because there is no such thing as a perfect investigation. So that's the last refuge of a criminal defense attorney with a criminal client. He always has that to talk about, because no investigation is perfect. No investigation does everything. There's not an infinite amount of resources and time and money and officers to apply to any case. So it's always falling short in some respect. And of course, because that's the last refuge of a defense attorney with a guilty client, that's what it sounds like when they go to this argument. So I'm not a fan of this argument, unless, of course, your client looks guilty and you don't, in fact, have the law and facts on your side. And then there's really nothing else for you to do but talk about the investigation. So I think this line of argument is weak. If they're making an insanity defense, where's the evidence of insanity to the legal standard? I mean, that's what they ought to be arguing. Oh, by the way, I see in the comments that apparently the judges on Friday explicitly declined a self-defense jury instruction. So there is no, if that's the case, there will be no self-defense jury instruction here. And this would be an unusual case of a defendant failing to meet his burden of production on the legal defense of self-defense. So you don't have some automatic right to argue self-defense at trial. You have to qualify to argue self-defense. There has to be some minimal prima facie evidence in support of those required elements of self-defense in order for you to meet what's called your burden of production. That's the burden on you, the defendant, to get the legal defense of self-defense into court in the first place. You have to meet that burden of production. Now, you don't need a lot of evidence in support of each of the required elements. Basically, you need more than zero evidence. It's not a lot, but it can't be zero. If one of these elements required has zero evidence, it doesn't exist for legal purposes. And if it doesn't exist and it's a required element of self-defense, then you don't have self-defense. And if you don't have self-defense, there's no point giving the jury an instruction on self-defense. Now, normal good guy cases of self-defense don't usually have a problem meeting their burden of production. Basically, all that has to happen is for the defendant himself to make a statement that it was self-defense. But here, the defendant himself says he has no recollection of the critical events, of the firing of the shot. So he can't do that. And I guess, certainly from what I heard, and apparently the rest of the trial, there was not sufficient evidence on the burden of production to warrant a self-defense instruction. So we have a relatively unusual case, because self-defense was mentioned in opening. by defense counsel, by this defense counsel, Belinka's. But apparently they were unable to meet even their very minimal burden of production on self-defense in order to qualify for a self-defense jury instruction. Now, had they qualified for that, the state would have the burden to disprove self-defense beyond a reasonable doubt. But because they failed in their burden of production, there will be no self-defense jury instruction. There will be no burden on the state to disprove a legal defense not in play. That legal defense is self-defense.
Reasonable doubt, the linchpin of the criminal justice system. Reasonable doubt may arise from the evidence itself or the lack of evidence. As I said, the prosecutor's entire case is based on counteracting Goodwin. The investigation stopped after Goodwin pointed Barisone out. The evidence is clear that the prosecutor never looked at the events leading up to the incident. The evidence will show that they ignored critical, precise evidence which would have shown you exactly what happened. Evidence that if they had conducted even the most basic scientific analysis, would have addressed many questions, unanswered questions that I suggest you should have.
All right. So first of all, yelling is not a legal defense, and that's what Belinkas is doing here. He's just yelling. Yelling is completely unimpressive to me. I mean, used with discretion, it can have emotional impact. But if he's going to yell his whole closing argument, that's, if anything, that suggests to me that he doesn't have substance in the closing argument. So hopefully it's not going to be 2 hours of him shouting in the courtroom. Maybe that's all he has is volume. So if that's all you have, I guess that's what you work with. But this notion he's making, the argument he's making here, the suggestion that, hey, it's the defective investigation by the police. If only they had asked these very simple questions, done these very simple steps in their investigation, we'd have the evidence we would need to understand what really happened here, presumably the insanity defense. But here's the difficulty here. The burden's not on the state to disprove insanity. The burden's on the defense to prove it. And the absence of evidence does not help the defense prove insanity. The absence of evidence is their problem. The burden's on them. You know, normally in a criminal prosecution, the entire burden is on the state. Even in self-defense cases, the burden's on the state to disprove self-defense. And in theory, the defense could just sit there and wait for the state to fail to meet its burden. But here the burden's on the defense. The defense had better come up with whatever evidence is required to prove insanity by a preponderance of the evidence. They can't just point a finger and say, well, you know, we don't have the evidence because it's their fault. It doesn't matter whose fault it is. Either the evidence is there or it's not. And if it's not, the defense has failed its burden on insanity, and the insanity defense fails.
Instead of doing that, instead of doing a thorough, unbiased investigation, they chose to rely on those two witnesses who clearly have a motive, who admitted in this courtroom to having a plan to destroy Michael Barisone and his business. Their whole case with regards to what happened prior to the shooting, when the beating of Michael Barisone occurred, where and when shots were fired, and when a dog attacked Michael Barisone in relationship to the beating that he received. Look, ladies and gentlemen, at the lack of evidence. Ask yourself, what is the most reliable and unbiased piece of evidence in any criminal trial? Video surveillance. You can't change its content. You can't alter it.
Well, you can.
You can't lie about what's actually depicted. Where's that video? Ask yourself, where is that video? Why didn't the prosecutor or the police seize it on that day? They're asking you to rely solely on the testimony of Robert Goodwin with regards to the content when he turned that off. That's the only evidence that they're asking you to rely on. Clearly, on the night in question, the Washington Township Police Department and the Morris County Prosecutor's Office were made aware of that camera and the possibility that it had captured this entire event. Why didn't someone from Blink testify? There's got to be some record with regards to those cameras. 3 different cameras, according to Goodwin. When was the camera turned on? When was it turned off? What did those cameras capture? How long do those images are they retained in the cloud? If you turn off an inside camera, as Goodwin said, does that affect and disable the camera outside that would have depicted this entire incident? Where's that testimony, ladies and gentlemen? They're asking you to rely on Robert Goodwin. Doesn't it seem a bit odd, too big of a coincidence, that Robert Goodwin just happened to turn off that video on the day of the shooting? The evidence before you shows that the camera was working on the day before, on the 6th. Recall the testimony about the video capturing Ruth Cox going into the farmhouse the day she got bit by the dog. I submit that's too big of a coincidence for you to rely on, especially when there's been testimony that Lauren Canarak was talking about finishing Michael Barisone that morning, especially when Canarak and Goodwin had a discussion a few days before about disarming Michael Barisone's web cameras. Why would anyone, ladies and gentlemen, under any circumstances, want to disable someone else's camera unless they didn't want what they were going to do to be depicted on that?
So it's not clear to me what he's arguing now. I mean, this is not insanity defense argument. This is what? That it was self-defense? That they attacked Barisone first and he shot them in response? Because there's no evidence of that. I mean, he's trying to suggest here that the absence of evidence is supposed to be evidence, but it's not. And there's no claim. Barisone himself is not claiming that because he claims he has no recollection. So this is just imagination and hand waving.
You still want to believe Robert Goodwin? I submit, ladies and gentlemen, that lack of evidence calls into question the entire sequence of events. I submit, ladies and gentlemen, that is reasonable doubt. Reasonable doubt begins when the camera is shut off. The prosecutor has to answer that. You should demand a response to those questions.
Well, this is just deceptive. The standard of reasonable doubt doesn't mean that you have to have certainty beyond a reasonable doubt on every facet of what happened. The standard of reasonable doubt applies to the elements of the crime. That's it. If something's not an element of a crime, the state doesn't have to prove that beyond a reasonable doubt. The state doesn't have to prove beyond a reasonable doubt what color shirt was on the defendant was wearing. Doesn't have to prove beyond a reasonable doubt what he had for breakfast that morning. I mean, there could be uncertainty about all such manner of things. It's got nothing to do with whether or not the state has met its burden. So just suggesting that you might have reasonable doubt because a camera was turned off, it would have to be reasonable doubt about some essential element of the criminal charge.
If he says it doesn't matter, I have 2 eyewitnesses, Mr. Belinkus. Question everything else that comes after that. Those witnesses had a plan to destroy Michael Barisone. One of those witnesses is the person who testified was the one who disabled and turned off that camera. Let me throw a little more gas on that fire. When the police get there, no one's holding a gun. The gun is on the ground. Why didn't the police do DNA, fingerprint testing on the gun, the magazine, or the casings? Why didn't they do that gunshot residue on Michael Barisone's hand to determine if he had fired the weapon? You saw in Captain Fellini's affidavit that the judge gave them the right to do that.
I mean, this is just silly. So, sure, okay, so maybe the victims here would have motive to lie about what happened. Lauren Canarak was shot twice in the chest by a gun that was given to Michael Barisone. That's uncontroverted. We're supposed to believe that, that Lauren Canarak or Robert Goodwin secured the gun from Michael Barisone's possession and shot themselves with it to set him up? I mean, that's one way to go, but is that a more credible view of the outcome of these events than that a hotly hostile, toxic relationship resulted in Michael Barisone taking the gun he had possession of and shooting them?
Why not do that?
Especially in the complete absence. I mean, there's evidence. You could believe it or not to believe it, but there's evidence consistent with Barisone shooting them. There's no evidence of them shooting themselves or at themselves.
You are searching for the truth. Do everything. Cross your T's, dot your I's. And why didn't they ask for gunshot residue testing on Canarak or Goodwin? No. The prosecutor wants you to rely on those witnesses. Let's talk about their crime scene investigation. I submit that the investigation conflicts with Canarak and Goodwin's testimony, their version of events. They say 3 shots were fired. Look at the photos and all the evidence that comes before you. They only found 2 shell casings. Where's the third? You can't have a shot without a shell casing.
As someone who's fired literally hundreds of thousands of rounds out of semi-automatic pistols, especially during my competitive career, and who reloads his own ammo. So I need that brass. I need that ejected brass in order to reload it for the next time around. You never recover 100% of your brass, folks, and that's just not the way it works. A few of those little suckers always manage to scurry away somehow.
Admit that Canarak and Goodwin are lying about that third shot. Is it possible, is it conceivable that one of the 2 bullets that had gone through Canarak's body hit the door? Is that possible? Should anything have been done to try to confirm that or rule that out? If there is no third shot, there is no attempted murder on Robert Goodwin. Let's look at Canarak's testimony. Again, a witness who admitted on the stand to having a plan to destroy Michael Barisone. Stop and think for a second of the magnitude of that statement. not only was she angry or upset with Michael Barisone, but she made a conscious decision to try to destroy someone. Who does that?
Well, a witch,
Who goes?
a witch, a horrible person. I mean, I'm convinced that she made an intentional decision to destroy Michael Barisone on every level, mentally, psychologically, professionally, reputationally, socially. She comes across to me as an unbelievably toxic and horrible person. But that's not a justification for shooting her. And it's not evidence that Michael Barisone was insane in the legal sense at the moment he pulled the trigger.
Goes to the extent that Lauren Cataract and Robert Goodwin went to.
This is what I've been referring to as the emotional defense, not a legal defense, but the emotional defense is she is such a witch that she earned it. I mean, come on.
If you recall Cataract's testimony, the evidence came out on cross, not on direct with the prosecutor's question, that prior to the shooting, she was planning on suing Michael Barisone. I also brought out that she currently is suing Michael Barisone and has a financial interest in the outcome. I submit, if you believe Lauren Cataract walked into this courtroom, put her hand on this Bible, and intentionally lied to you, disregard her testimony. Why do I say that? Now, the judge allowed certain evidence in for a limited purpose to impeach Ms. Cataract, or evidence that relates to Michael Barisone's state of mind. This is not character evidence. I submit to you, ladies and gentlemen, that Lauren Cataract lied to you numerous times. Let's go over the lies. Number one, she lied about the recordings. She lied that all the recordings, where she and Goodwin were not present, were recorded from her locker in the stable. And Goodwin jumps in and says the exact same thing, but we'll deal with him in a minute. That statement is clearly a lie. There is evidence in the record that proves she's lying. Recall Robert Goodwin's testimony when he recorded the meeting with Cataract, the father, and their own lawyer, where they're talking about the recording and where Cataract said that all the recordings were done from her locker. And you recall Robert Goodwin's response? At least that one, ha, ha. That testimony, number one, proves that Cataract is lying about that, I submit, but it also cast doubt on their attorney, Edward David, which I submit to you, you should disregard everything that he says. He was one of the two people that Cataract said gave him permission to do these secret recordings. When I questioned him or tried to talk to him with regards to anything about these recordings, what was his response? I have no recollection of that. You know, he wanted to stay away, as far away from that as he possibly could. Why? Well, maybe they were illegal. You know, maybe his license.
All right, so all these people were lying liars who were telling lying lies in their testimony on the witness stand. Not just the victims, but their attorneys. I mean, what would be his incentive to lie? To commit an act of perjury. I mean, it's not just a perjury issue. I mean, people lie in court all the time. They're hardly ever held accountable for perjury. But for a lawyer to lie in court, that would be career threatening. He's going to do that for what? For what reason? But even if it's all true, even if they're all a bunch of lying liars, how is that evidence that the client was insane at the time he pressed that trigger? I'm not seeing it.
May be at jeopardy. He said over and over again, I don't recall having a discussion. Even when I showed him the transcript that I cross-examined Goodwin with, where they talk about the recording and where it's being done. Oh, I don't have a recollection. Oh, it was 2.5 years. He didn't even want to look at the transcript. What does that tell you? And if anyone else, strike that. And further with regards to Davis, when you recall his testimony, he testified on the phone that he heard a struggle. And then he said he testified here, a shot. But in his original statement, he said clear as a bell that he didn't know it was a shot. But after talking to everyone, being prepped for trial, he comes in here and testifies under oath that it was a shot.
Well, she was shot. It's incontroverted.
If you need further evidence that Cataract is lying about those recordings, recall Mary Haskins Graves' testimony, Mary DeFranco's testimony, the attorney for Michael Barisone, Stephen Tarshish's testimony. Those 3 witnesses unequivocally told you that during this time, they had private conversations with Michael Barisone in the office and in the club room. And that after those conversations, Lauren Cataract posted their exact words. The office has been testified is over 100 feet away from her locker. The club room is literally 40 feet. Both rooms are separated from Lauren Cataract's locker by a closed, solid door. Did she lie in this courtroom? I submit there's overwhelming evidence to support that. I submit that she lied about her social media posts. She lied about what she posted and who she posted about. Do you recall her testimony when I confronted her with something that was damaging to what she said and damaging to the prosecutor's case? When I confronted her with her own words, she denied originally making that post. When I walked up, showed her the exact things that she had posted or texted, she said, probably. I counted 16 times she used that word. If she didn't use the word probably after being confronting with her exact words, she said things like, I don't recall if that's what it says. She refused in just about every instance, ladies and gentlemen, to admitting to exactly what she had done and her exact words with regards to that. The only person that does that is someone who's trying to deceive you. Use your common sense. Use the ability that you use every day in your life when someone tells you something and you don't know them. And you consider all the factors that everyone does in making a decision as to whether or not someone is being truthful with you. Is there anyone in this courtroom that if presented with their own exact words on a post or a text would hesitate and accept that that's what you did say.
I mean, this is just, listen, Canorak comes across to me as a complete witch, a monster of a human being, a completely toxic individual I certainly would not allow within any circle of my personal life. But it's rather normal for people to say, hey, did you write this thing in social media 2.5 years ago? To say, I don't know, maybe. And when you show it to them, they say, well, it looks like it. If that's what's there, that's what I wrote. That's not a lie. That's just a person without an actual recollection of it who's willing to acknowledge the apparent truth of the claim when it's presented to them.
She also lied about not sneaking around in the woods at night.
Somebody just commented, saying nice things. They enjoy my channel, but they don't know my name. The name's Andrew Branca, folks. Andrew Branca at Law of Self-Defense. Welcome aboard.
Now, you've heard everything that Lauren Canorak has done for Michael Barisone. You heard from Michael McGrain. Remember, he testified there was one instance where she was in the woods sneaking around. She was dressed in all black with no shoes on. She lied to you. There is evidence that she lied to you. She also lied to you that the reason why she didn't leave was because she couldn't find a place to house her horses and train both her and those horses. You have the sworn testimony of Michael Barisone's attorney, Michael Tarshish's, where he says he told her, I got a place for you. It's right down the road.
It's not Big Branca for
With
the ladies.
an Olympic
It's
quality
Big Branca for the lady
athlete
singular,
to train
folks.
you and
Happily
your
married.
horses. Lauren Canorak didn't want to leave. Lauren Canorak was never leaving that property. Lauren Canorak was getting free living accommodations. She was only paying for 2 horses. That was a lie to you. She also said she was never officially told to leave. Attorney Steve Tarshish took that stand and said, that's not true. I served an eviction complaint on her.
An eviction complaint never filed with the court. So is that an official notice to leave? I mean, it's just, he's using the language here in a very ambiguous way. She was told to leave by Michael Barisone many times, but he invited her to live on the property. That makes her a tenant. Whatever you think of her, tenants have rights too. And she was asserting her rights. She could not be obliged to leave. And even the eviction notice given to her was, it was not genuine in the sense that it was not filed in court. It was just intended to scare her into believing an eviction was in process, a legal eviction.
He had the proof of service that she personally received that document. Now, I'm sure the prosecutor is going to say, well, that was a dummy complaint. And, I don't even know what he's going to say or comment with regards to it. But the fact is, ladies and gentlemen, she was officially served. Whether it's a dummy complaint or not, she still had an official document to leave.
Again, nothing to do with insanity defense.
She didn't know it was a dummy complaint before the shooting. She didn't say, well, I got a complaint and my lawyer looked at it, we checked it. She said, I never was officially served. Lie number 6. Let's go to number 7. Recall her testimony.
Can tell people in the comments haven't been landlords dealing with difficult tenants. Folks, if you're a landlord and your tenant has rights and they're asserting their rights and you take all their stuff and throw it out in the street and change the locks, you're in a lot of legal trouble. You're not allowed to do that to them any more than they would be allowed to do that to you. So you may not like landlord-tenant law, but that's the way it works in a lot of states in this country.
With regards to why she turned Michael Barisone into the town. Remember that 2-page letter that her and Goodwin had concocted? her testimony to you was that there was a faulty dryer. You know, we were concerned the barn was going to burn down. Do you really think that that was her motivation? Or do you think it was part of her plan, like all these other things, to destroy Michael Barisone?
Yeah, probably the latter, right? Listen, I've never owned a horse, but if you're a horse owner, and you love your horses, and you have them in a barn, and you look around the barn and you see things that look to you like a fire hazard, are you not going to remove your horse from that barn immediately? Would you leave your children in a building that you thought would at any moment catch on fire? So I don't believe that she believed that there was a genuine fire hazard there. I believe she was calling the code authorities simply to cause trouble for Michael Barisone. She was a witch. That's what she did. But that's neither evidence of insanity on the part of Michael Barisone nor any justification for shooting her. As much as you might like to live in a world where that would be justification for shooting her, it's not legally.
If you're concerned about a faulty dryer, if you're concerned about it possibly starting a fire, pull the plug out. You don't need to write a 2-page letter trying to get Michael Barisone kicked out of his last place of refuge. Do you really honestly think, ladies and gentlemen, that that was her motivation? A faulty dryer. Based on everything that you know at this point, I submit that she lied to you. Finally, with regards to her bold-faced, despicable lies in this courtroom, is she lied about not searching for DIFA's anonymous hotline. Recall her testimony. When I confronted her, did you call DIFA's? No. When I confronted her on the stand with her own phone records indicating that she had searched DIFA's anonymous hotline on 2 separate occasions, on 2 separate days, what was her response? How could she explain that?
Well, you can explain it by saying, you asked me if I called. I didn't call. I may have searched for their number. That doesn't mean I called. I mean, this is just silly.
Her explanation? Oh, someone must have stolen my phone. And then she tries to blame it on Justin Harding. Do you honestly believe there's any possibility on the face of the earth to think that Justin Harding would steal her phone to look something up? Not once, but on 2 separate occasions. If she's lying about this, she's lying about the shooting. She's lying about the incident. If the lies are not good enough for you, good enough to convince you not to believe her, look at her inconsistent statements. And just like you do in everyday conversations, if someone says something one time.
Again, all of this stuff, she was inconsistent, she lied, the evidence is incomplete. These are all arguments you make when the other side has the burden. And you're suggesting they fell short of meeting their burden. And in that context, these are perfectly reasonable arguments, but that's not the legal landscape here. The legal landscape here, they're arguing insanity defense, is they have the burden. They have to prove they have to prove insanity by a preponderance of the evidence. Arguing at length about how there's a lack of evidence does not help them meet their burden.
And then comes back and says something different. Don't you normally question the truthfulness of those statements? And again, it depends on the significance, but that's a common thing that all of you do. Look at Cataract's inconsistent statements. She originally told the prosecutor's office soon after the incident that she disappeared. She doesn't even know where she went.
Well, she'd just been shot twice in the chest.
On cross, when I tried to question her with respect to that, she comes up with this crazy story that she meant disappearing in her mind. And then I asked her, did you run away or walk away from the area? And she demonstrated what she claims that she did. She also never mentioned in her original statement that she beat Michael Barisone for 7 minutes. On direct, before I cross-examined.
By the way, anybody interested in seeing the actual New Jersey insanity defense statute, you can find that at lawofselfdefense.com/New Jersey insanity. One word, New Jersey insanity. I know that could apply to the entire political structure of the whole state, but that shortcut link, NJ insanity, not the words New Jersey. NJ, the abbreviation insanity. One word. Lawofselfdefense.com/NJ insanity will bring you to the New Jersey insanity defense statute.
Before I showed her the post in her own words about beating him for 7 minutes, she tried to make light of what she did. She said, I hit him a few times.
Yes, folks, we're a
7
couple
minutes
hours behind the live.
is
So if you
not
prefer to go
a
watch the
few
live,
times.
go do that.
She testified before you that she had gone up and down the stairs.
Nobody
numerous
testified
times.
that Michael
She
Barisone was
never
on the
said that
ground
in
when
her
he shot
original
Lauren
statement. I'm gonna
Canarac.
get to
Nobody.
that
There's no
in a
evidence of
second.
that.
And I submit, if she did do what she said in this courtroom about going back and forth as she did, that it was before any shot. In her original statement, she said Robert Goodwin was in the house at the time of the shooting. Recall, I brought out that in her statement. She said she ran to the door after being shot and told him not to come out. Now she's saying on direct examination that he was outside. Major inconsistency. What should really bother you, ladies and gentlemen, and I'm going to ask you when you get back in that room and you start talking about things.
So someone just posted a super chat. In fact, let me catch up on the super chats real quick. This is get a little break from the shouting. Let's see. Content of character, also on the Law of Self-Defense members page. Thank you very much. Writes here on YouTube. The argument is not legally effective, but if I was on the jury, it would give me an out to vote not guilty. Also, Andrew, when will you do another in-person class? So, two separate questions. Yeah, I mean, this could be all part of that. As I said, the emotional argument, not a legal defense, but an emotional defense. Lauren Canarac is a witch. Robert Goodwin is the boyfriend of a witch. These are monstrous people who set out to intentionally destroy Michael Barisone on every level. And therefore, you should forgive my client for shooting them. I mean, that's an emotional argument that he's apparently is the only real argument he's making to the jury so far in closing, because he's not arguing insanity. I mean, none of the evidence, none of the claims of evidence or absence of evidence he's pointing to here for the last almost hour have anything to do with meeting the defense burden of proof by a preponderance of the evidence on the insanity defense. There's nothing here that's really relevant to self-defense, which apparently is off the table anyway, because the defense failed to meet their burden of production. So self-defense as a legal defense isn't even in play. So yeah, maybe a purely emotional argument, and maybe it'll work. Maybe the jury will buy that. I mean, no, jurors don't explain to anybody how they arrive at a verdict. So they could just decide Lauren Canarac sucks so bad that she deserved to get shot by Michael Barisone, and they're not going to convict him of a crime for having done that. Maybe, I guess we'll see, but it's not a legal argument. Content of character, another super chat also asked, do we know the timeline of events? Defendant can't remember, and we know he was beaten. Do we know he didn't shoot after being attacked? So this is a great question in a meta sense, because we don't know, but the answer to the specific question is less important really than how we answer these kinds of questions. Nobody knows what actually happened. Nobody ever knows what actually happened. Nobody evaluating this case was there. The cops who responded were not there when the shots were fired. The judge was not there. The prosecutor was not there. The defense counsel was not there. Certainly the jury was not there. So nobody knows what actually happened in any absolute sense. How we make decisions in the trial context about what we believe happened is we look at the evidence and we make reasonable inferences from the evidence. If there's no evidence from which to make an inference, you can't make the inference. There is no evidence here that Michael Barisone was attacked before he shot. There's none. So to come to that conclusion would be a matter of pure speculation, imagination, and speculation and imagination free of evidence have no role in a courtroom. The jury's instructed that they are supposed to be basing their verdict on the evidence or absence of evidence on a relevant point. In other words, if somebody makes a claim, but the absence of evidence doesn't support the claim. The absence of evidence undermines a claim that was made. So if the defense were to claim that Barisone shot only after being attacked, the absence of evidence of that would undermine that, not support it. There's no evidence here, none, that Barisone shot while he was on the ground, that Barisone was attacked first. No evidence of this, not even from Barisone. And if there's no evidence of it, you can't come to that conclusion rationally. Okay, back to the shouting, the shout fest.
Look at the crime scene photos. The crime scene photos introduced by the prosecutor. And I have one here. What should really bother you is the location of the phones at the crime scene. How did Michael Barisone's phone get on that table? On that round metal table by the bush? No one talked about him having a phone in his hand. Cataract and Goodwin never talked about Robert Goodwin having a phone.
Again, the absence of evidence
If you're
is
going
not
to shoot
evidence.
somebody, if you're coming down there to kill somebody, why would you have your phone in your hand? How did Michael Barisone's phone get on that table? Was there an argument? Did he try to call 911 like he had done many times and an altercation started? How did Michael Barisone's phone get on that table? More troubling. And I ask you to look at the photographs. How did Lauren Cataract and Robert Goodwin's phones get at the base of the umbrella stand?
So the commenter here, whoever Navy girl is becoming increasingly tiresome. Who can run around and up and down steps after they've been shot? Well, Navy girl, in 1986, a gentleman called Michael Platt was shot in the heart with a 9mm pistol fired by FBI agents on a stakeout, a rolling stakeout, looking for bank robbers. Michael Platt and his co-conspirator. Platt was shot in the heart with a 9mm, fatal injury. If he'd been put in an operating room in that instant, he would have died. Shot in the heart with a 9mm, went on, after being shot in the heart, to kill 2 FBI agents and wound several others. So yeah, you can be shot and still be active.
Both phones are at the base of the umbrella stands. That is totally inconsistent. That is reasonable doubt.
The fact that things may be inconsistent and in doubt does not help the defense here. The burden is, if they're arguing insanity defense, which appears to be their only defense, their only legal defense, they have the burden to establish insanity by a preponderance of the evidence. Uncertainty does not help them. The burden's on them. They need certainty, at least to the degree of a preponderance of the evidence.
Disputes what Cataract and Goodwin said. Recall her testimony regarding the use of the phones. This is important, and it should send a shiver up your spine. She says she's holding Robert Goodwin's phone when she's shot. Remember, she's on the phone with her civil lawyer. That should raise a red flag on its own. She says after being shot, she put the phone down. She walks over, climbs up the stairs, and grabs her phone. She says she tries to call 911. I don't know why she didn't try to call 911 on Goodwin's phone, but this is her testimony. She says she tries to call 911. Her phone doesn't work. She puts it down on the top landing. She walks down the stairs. She walks over to where she placed the phone down by Goodwin and Barisone.
I love the little dress rehearsal motion.
She picks up Goodwin's phone. And calls 911. That was her testimony. And you heard the 911 call. At some point during that
I mean,
call,
I've been thoroughly unimpressed
she
with this
hands the
attorney
phone
throughout the
to
trial
Goodwin.
from his first words and opening statement. But
She
you know,
then
I have to
said
concede he just may have nothing
she
to work
walks
with.
back up the stairs,
More up the stairs.
retrieves her phone, turns, walks down the stairs, walks over to where Barisone and Goodwin are, and starts beating Michael Barisone with her phone for 7 minutes. So we have the 911 call. We have her beating Barisone in this area. How do the phones get on the umbrella base 10, 12, 13 yards away?
He's just trying to count up, accumulate steps on his
All
exercise watch.
supposedly after being shot. Does that make sense to you? Is it physically impossible for someone to be shot in the chest twice and do all that?
Yes. Demonstrably.
Let's look at Robert Goodwin's testimony. I submit, ladies and gentlemen, that based on what you know about Robert Goodwin, that he would do or say anything to help Lauren Cataract. After all, she's the one paying for everything. She's the one getting them free living accommodations.
She's the source of
She's
nookie.
paying him to hang around with the horses. Remember, he is one of the people, him and the father, who had a plan to destroy Michael Barisone.
That could be true.
He was the one, ladies and gentlemen, that purchased all the recorders and cameras. He was the person that was secreting the recorders and then retrieving them on behalf of Lauren Cataract.
There's not going to be any
He's the
defense
one, ladies and
under
gentlemen,
New
who wrote
Jersey
the
law
letter
for
to
the,
the
for the gun
town.
crime, folks.
He's the one, ladies and gentlemen, that turned off the camera that would have captured this entire incident. In his original statement, he said he only heard shots. In this courtroom, before you, he claims that he actually saw Michael Barisone shooting. Totally different, inconsistent with his statement
I know,
The
30 years of
night
criminal law experience, this
of
guy,
the incident.
including time as a federal assistant U.S. attorney, I'm told. Doesn't look like it.
Some things that Goodwin did say that are helpful. Michael Barisone was never violent. Michael Barisone never threatened him or Lauren Canarak. He totally disputed the prosecutor's statement that Michael was angry and furious at the time of the shooting. Described him, as I said, calm and sorrowful. But he also lied to you. He told you the same lie about those recordings. And again, I'm not going to go into the transcript with the lawyer, but clearly, ladies and gentlemen, those recordings were not all made from Lauren Canarak's locker.
I don't know how Chewbacca references got into the chat, folks, but I can tell you this: if anybody ever offers you a Wookiee steak, don't try it. I tried it once; it was chewy.
In his original statement, he said the same thing Canarak said in her original statement, that she disappeared. He testified in this courtroom that Canarak only hit Barisone in the face a few times. That's inconsistent with the 7-minute beating that Canarak posted about. What's also important, and I don't know how much significance you think this is, neither of them ever mentioned that their dog had attacked Michael Barisone. And we're not talking about a simple nipping. You heard medical testimony from the doctor that treated Michael Barisone that he had numerous puncture wounds all over his body. One of which was a puncture wound to his inside groin area. How did that happen?
Nobody disputes how it happened. The dog bit him. The dog of Lauren Canarak and Robert Goodwin bit Michael Barisone repeatedly. No one's contesting that. Of course, the evidence is that the dog bit him after he shot Lauren Canarak and Robert Goodwin, which is kind of what you'd expect your dog to do, even if it's 20-pound Rosie. Rosie was just doing her job, is what the evidence tells us.
When did that happen? Why didn't Canarak, why didn't Goodwin ever mention that the dog was mauling Michael Barisone?
The dog's got nothing to do with an insanity defense.
And what I submit should offend you is the prosecutor introducing a cute photograph of the dog in the background, just sitting up and, very, very calmly. That dog attacked Ruth Cox. That dog attacked Michael Barisone. That dog even attacked the police officer who arrived on the scene. His name is Rosie. I'm calling it Cujo. Why would the prosecutor even think about introducing that photograph?
20-pound Cujo.
What possible reason other than to try to give you a different impression? The defense put on 2 highly qualified, distinguished experts. Those two experts, ladies and gentlemen, I believe are far more compelling and believable than the state's one expert. They spent more time with Michael Barisone and did a much more thorough evaluation than the state's doctor, Dr. Schlesinger. Most important, Dr. Simmering saw Michael Barisone soon after the incident, within a month, and he testified and was never disputed by the state.
Folks, this video from the courtroom is a couple hours behind the live stream. There's no point me being concurrent with the live because I pause all the time to make comments. So if you want to be completely up to date to the moment, what's happening in court, go to the live stream. Don't stay here. Secondly, I see it mentioned a few times in the chat, the Amber Heard Johnny Depp trial. That's not I'm sure it'll be great fun to watch, but it's not a trial I'll be covering. It's not a self-defense case. I'm sure Nick and crew will be following it in detail. Maybe I'll pop in there from time to time for laughs and giggles, but I would not be the source for a detailed coverage of the Johnny Depp Amber Heard trial.
Doctor, that it's important and you get a better sense of what happened and a better evaluation if you evaluate someone close in time to the incident. Does that make sense to anybody? Is that psychological mumbo jumbo? It's important that when you're considering these experts, the defense and the state, that you consider that the defense experts do both work for the prosecutor's office and defense lawyers.
Okay, and
if you look at Dr. Simmering and his testimony, his credentials were amazing. His experience was amazing. And what's important and what you should consider is that.
so
he's
we're closing
been
in on an
hired
hour
numerous
in here, and I've heard
times by
nothing
the
that would
Morris
support a
County Prosecutor's
insanity
Office.
defense argument.
This office that is prosecuting this case, he's indicated he's been retained. He's been relied on by that office many times. It's going to be interesting to see how the prosecutor attacks him when their office has used him numerous times. Dr. Simmering is a psychiatrist, a medical doctor. He's clearly more educated, has more experience than the state's Dr. Schlesinger in evaluating people in criminal cases. What's odd, ladies and gentlemen, is that although Dr. Schlesinger, the state expert, says, I disagree with Dr. Simmering's diagnosis, he never explained why or what the basis was. Clearly, he had no problem attacking Dr. Hassan, one of the defense experts.
I don't think he
After
physically
Dr.
attacked him in
Hassan
the courtroom.
corrected and questioned the method and scoring of the test he gave Michael Barisone. I submit to you, it seemed like almost a personal attack. Like, how dare you question me? When someone says things on the stand like, geez, I don't want to be too critical of someone, and then clearly goes out of their way to attack them, you should question their testimony.
Oh, the defense definitely cost in the six
The
figures
fact
easily.
is, with
easily.
regards to the
Multiple
state
of that.
expert, Dr. Schlesinger, he spent, and I timed it, 45 minutes talking about himself and all his awards.
Well, that's what experts do.
No
That's how you
time
qualify an expert.
telling you why he disagreed with Dr. Simmering. He also
This defense attorney just talked about his own expert, saying you heard at length about all his qualifications and how amazing he was. But the state expert is not supposed to go. They have to ask those questions to qualify the witness as an expert in court.
Also testified, and I asked you to recall this point, that he only spent about an hour or so testing Michael Barisone. That's only 15 minutes more than him talking about himself. The state's doctor.
So if insanity works, if the jury were to acquit, not guilty by reason of insanity, he would not go to prison because he'd been acquitted of the criminal charges. He'd be subject to institutionalization. Now, whether he would actually be institutionalized or for how long, whether he's actually institutionalized is up to the judge. The judge we'd have hearings then, and the judge would hear from more experts, and the experts would testify about a level of dangerousness and all this kind of stuff, and the judge would make a decision about whether to order him institutionalized. But that's what he'd be subject to. It's at the discretion of the judge. Once he's institutionalized, then it's largely up to the doctors at the institution to determine when to release him. When they conclude he's no longer a danger to society would be the normal standard, which could be in weeks or in months or years or theoretically never.
Dr. Schlesinger said he only spent 13 hours total with Michael Barisone.
Anyone who just is hopping in now and doesn't know this case, you could just backtrack to the beginning of this live feed, and I do I think a reasonable summary of the facts and law of the case.
As compared to 37 hours that Dr. Hassan, one of the defense experts, spent. I submit, ladies and gentlemen, that the state's expert's testimony appeared rehearsed, scripted. How many times did he volunteer things, talk about providing the prosecutor with the articles or books? Oh, I gave you that article, prosecutor, or that book I gave.
He's not supposed to do that.
I now know where the prosecutor got those articles.
That's wrong.
That he used to try to attack Dr. Hassan?
Well, that's what your expert
Dr.
is supposed to do for you.
Schlesinger give those articles and books to Prosecutor Shellhorn when everybody knows, and it's been testified to, there are an equal number of articles and books in the psychiatric field that say the exact opposite thing.
Well, that's for you to bring up. It's an adversarial process.
Dr. Schlesinger basically is a hired gun for prosecutors' offices in New Jersey and New York. He testified he has another case with this prosecutor's office. He tried to soften that when I had brought out that my experts do work for both sides. Always have, always will.
I see in the comments someone mentioning
tried
how
to
old Cujo
soften
is.
that
I'd
by
forgotten
saying,
because I'm old.
Well, the first third of my
Cujo, the
career,
movie, came out in 1983.
I did work
My
for
senior year in high
defense
school.
lawyers. The second third, I did both. But basically, the last third, I'm doing almost exclusively work for the prosecutor's offices. Well, if you divide up that 30-year career, the last 10 years, all he's been doing is rendering opinions for county prosecutors' offices all over the state. And I'm going to ask you to use your common sense. How long do you think he would keep doing that if he didn't support the prosecutor's position? Not very long. The fact is, and what the evidence, and he didn't even dispute this, he did shorter versions of the tests he gave. He didn't do anywhere near as many tests as Dr. Hassan did. Dr. Hassan took Schlesinger's
Yeah, 83 was a good year.
his results
I can attest.
that he hand scored and put them into a computer program.
Well,
and
thank you
got
very
a
much.
totally
The super
different-
chats saying it was nice to see me at TACCON last month. I enjoyed TACCON. Oh, there was another question I forgot to answer earlier in the super chat. Somebody had asked me when I will do when's the next time I'll do an in-person class. I don't do a lot of in-person classes, folks, because they're too inefficient. I have to fly someplace. I have to go to a classroom where there's maybe 30 people, and I can do 100 people in a webinar class. So the only times I'm really in person is when I travel to someone else's event and give a talk somewhere 2 hours to 4 hours, typically, whatever they want me to do, but that's the usual length. And I only do a few of those a year. So I did it at Tactical Conference I guess last month. That's Tom Gibbons and Lynn Gibbons' annual tactical conference. I was there the year before. I was there this year, and I've been invited back for next year, and I'm happy to go. That's one of the premier events in the industry for a wide breadth of tactical training. Another one I do is the Guardian Conference. That's done by concealedcarry.com. I believe that's in September. I'll be speaking there. I think I do 2 4-hour classes there in person. So if you want to see me in person, you might try one of those events. They do tend to sell out pretty quickly. But that's where you get to see me in person these days, is usually at someone else's event.
A profile that confirmed the delusional disorder that he and Simran had testified to. The exact same data. He didn't make anything up. He took Schlesinger's data that he collected, put it in a program, and got a different result.
In the comments, I will concede that cars in the 80s sucked, but the 80s were so good it didn't matter.
What does that tell you? Dr. Hassan also did many more tests. He tried to look at this case and the diagnosis from all sorts of different angles. Schlesinger was focused. He had like blinders on. I submit that Dr. Hassan is not only consistent with Simran's diagnosis, but it also provided you with expert testimony concerning a battery of tests, a whole group of tests that he did that are also consistent with that diagnosis. What's really important and what should bother you, what should cause you to throw out Dr. Schlesinger's entire diagnosis is this. He never talked to Michael Barisone's therapist. Both Hassan and Simran did interviews with the therapist. A therapist that had treated Barisone on and off for 20 years. Schlesinger testified he looked at some text messages between the two, but never talked to her, never even attempted to talk to her. That, I submit, is important. And why is it important? Because you have two doctors, and it's not disputed, even by Schlesinger, that a person's prior psychiatric history is important. And a person, just like a regular doctor, have you ever had this before? You ever have family members that have had this or that? It's something
You
that's
ever have family
normal
members
in the
shoot a
field,
witch before?
as it is in the medical field. Particularly when formulating a current diagnosis. Both defense doctors had stated that based on that interview, that they were provided with information with regards to Michael's history. They were provided with information that Schlesinger never talked about traumatic events in his life as a child both of those doctors said that it's important and may make someone
Looks like about
more
another 30 minutes of
susceptible
this, folks.
to issues later on in life. Is that an outrageous, unreasonable statement? Or is it common sense? Use your everyday experiences.
Yeah, American Warrior Society, I would teach there in person too, but I don't think they're doing those American
Dr.
Warrior Society
Schlesinger, the state's
annual
doctor,
meetings
never
anymore.
mentioned that Michael Barisone.
If they are, they haven't invited me.
physically abused him. Never mentioned that Michael Barisone was sexually molested over and over again. Dr. Schlesinger never mentioned that his therapist had indicated he had issues with delusions prior to this incident. The same diagnosis, or related to the same diagnosis, as Dr. Simring and Dr. Hassan had testified to.
So a delusion is, of course, a psychiatric problem. You believe something to be true when it's demonstrably not true to someone who doesn't share the delusion. That's not sufficient for an insanity defense. So, for example, he may have believed that Lauren Kanarak presented as a deadly force threat to him, even though there's no objective evidence of that. She never threatened him with deadly force. She had no weapon in the moment which she could inflict deadly force. So he could have had that belief, delusional belief, but that doesn't mean he didn't know right from wrong. Those are two different things. Now, having the delusion may contribute to an imperfect self-defense, but you can't get to imperfect self-defense if you don't at least have a prima facie case of the other elements required for self-defense: the innocence, imminence, proportionality, and avoidance elements.
How can you just leave that out?
Now, yelling at the jury for 2 hours doesn't help your defense.
The state's doctor's position, and we're going to address this, is basically that Michael Barisone's fears are real.
Real or
And both
delusional? Don't you have to pick?
Barisone and other members believe that Lauren Kanarak's threat to kill was real and reality-based. Is he saying that Lauren Kanarak is in danger? Is he saying that Lauren Kanarak and Robert Goodwin had the wherewithal to kill Michael Barisone, his girlfriend, and their children?
If he is saying that, it's not helpful to the defense because they're not being allowed to argue self-defense. I mean, if they're arguing insanity defense, they need to argue not reality, but insanity.
If that's the case, if that's something that that doctor can glean just from reviewing the police reports as to what happened, why didn't Washington Township Police Department, why didn't the Morris County Prosecutor's Office intercede in the numerous times when Michael Barisone told them he was in fear, told them that Lauren Kanarak was dangerous, tried to show...
Because the police, they showed up. What are they supposed to do when they show up and there's no apparent, objectively reasonable threat to anybody? That's not a criminal problem. That's an argument between two people. That's a civil problem. The fact that one person may be delusional and think they're facing a deadly force threat, the cops show up, there's nothing there. What are they supposed to do? Arrest somebody because of your delusion?
Him all the posts and information that Dr. Schlesinger said clearly indicates that she is a danger and the danger is imminent. Remember, those two people are the state's case. Dr. Schlesinger then tries to bolster his opinion by saying, well, because other staff members also felt threatened, that proved his point. That's ridiculous.
So, folks, it doesn't. I have no personal investment in this case. This defendant's not a friend of mine or a family member of mine. It means nothing to me personally if he's acquitted or convicted. And I don't predict outcomes because I'm aware that there's sufficient noise in the system that you could get an outcome either way, independent of the legal merit. So just assume there's always at least a 10% chance of getting convicted, no matter how innocent you are, and a 10% chance of getting acquitted, no matter how guilty you are. That's just the noise in the system. So it doesn't surprise me when there's a verdict that's inconsistent with the law and the facts. All I can do is assess the probability based on the actual law and the facts. If a jury wants to run away and come back with an irrational verdict, that's within their discretion. Certainly there's nothing I can do about that. And them doing that does not change the legal analysis. The legal analysis assumes that they're not going to be irrational. The legal analysis is based on the facts and the law. That's what we do here at Law of Self-Defense. So it's just like, a Super Bowl game. I mean, either team could theoretically win. It's a matter of odds. Some teams winning, it's against the odds. Doesn't mean it can't happen. Of course it can happen. It's just not the way to bet.
Ridiculous.
Unless the odds
Every
make up for
person is different.
for the odds.
You don't need to be a psychiatrist or a psychologist to understand that. Some people are more susceptible to others. Look at all the people that you know. Is somebody stronger? Does someone hear or handle stress differently? Everybody is unique. Past medical history is also important. Dr. Simmering, Dr. Hassan testified that past psychiatric history, like prior traumatic events, can cause someone to react differently than someone who didn't have those events. Makes sense? Psychological mumbo jumbo? As I said, every person is unique. Every person has a breaking point. Some people are stronger than others.
Yeah, but a breaking point is not a legal defense. I mean, were you broken to the point of not knowing that you were shooting a human being? That's the question for the insanity defense. Where's the evidence of that?
The doctors that the defense put on looked at Michael Barisone as an individual differently than Schlesinger's general statements. They said that based on his past mental health issues, that specific things that were done to him caused him to react differently than others. The state's doctor never addressed Michael Barisone's unique circumstances. And again, let me point out an example why I think it's important.
I mean, I just think this is, I mean, there's like building blocks, there's bricks here from which to make a insanity defense. Finally, he's getting to the psychiatric expert testimony here. And there's pieces here from which to stitch together a coherent insanity defense argument, but he just doesn't seem to be doing it in a coherent way. I mean, essentially what he ought to be arguing is, look, our expert says our client was insane to a legal degree. Their expert says he wasn't. We have our burden to prove insanity by a preponderance of the evidence. This is why you should conclude we've met that burden. Our expert says this, and this is what supports that conclusion. Their expert said the opposite, but doesn't have that kind of support. So our expert has made a more majority of evidence supporting claim for his conclusion. Theirs has not. That's how this argument should be structured.
Counteract is something to both Mary Haskins Gray and Michael Barisone. Mary Haskins Gray is afraid. Michael Barisone crawls up in a fetal position, is inconsolable, and is crying hysterically. She testified that that happened numerous times. Clearly, Barisone is in a much different position than Haskins and everyone else at the farm. He's the owner of the farm. It's his business that they're attacking, not Gray's, not anyone else. He's the one responsible for protecting everyone. Most of the attacks are directed specifically towards him, that he abuses horses, is a criminal, did insurance fraud, that he is the one that has bullied Cataract and threatened her life. All those false allegations were against him, not anyone else. They have a different impact on him and everyone else. The house that he fled was his house. Haskins was just a girlfriend. No history, no investment in that property.
Just a
It makes
girlfriend.
a difference. If
She
I'm
feels
some
different.
place that I don't own and something happens, I could just leave. It's different when you leave your own house. It causes you to react differently. Michael Barisone had no one there to help him or protect him. Mary Haskins Gray had Barisone. Mary Haskins Gray had her father come and try to protect him. Michael Barisone was in a unique position. Michael Barisone was the one that Robert Goodwin took his hand, made it in the gesture of a gun, pulled the trigger, and told him the day before the shooting to get ready. Get ready.
All right, so let's assume that's true. I believe Goodwin denied having done that in his own testimony, but let's pretend it's true. This pointing the hand at the head as if it were a pistol, pretending to fire it, mouthing "get ready." That's a threat that took an articulation of a threat that took place the day prior, and that kind of prior threat evidence is relevant in the context of an imminent threat. So someone's doing something in the moment, just before you defend yourself against them. They're doing something threatening, an overt physical act in the moment. Those prior threats are context you can consider in evaluating their overt physical act in the moment. They threatened yesterday to shoot you. Now they're reaching for a waistband. But you need that overt physical act in the moment. You need some degree of imminent threat in the moment that's being contextualized by the prior threat. The prior threat alone is not enough to justify a later use of purportedly deadly force. And if there is no overt act, I mean, a good way to think about it is almost mathematically, the prior threat times the overt physical act equals the imminent threat in the moment. But if there is no overt physical act, if that value is 0, well, then the prior threat times 0 is 0, folks. There is no imminent threat. There has to be that overt physical act in the moment. The threat the day before by itself is meaningless for purposes of evaluating whether or not there's an imminent threat in the absence of some overt physical act in the moment.
Get ready.
And in any case, this is a self-defense argument, and self-defense is not on the table as a legal defense in this trial precisely because of the overwhelming lack of evidence even to meet the burden of production on self-defense by the defense. So all this has got nothing to do with insanity. If he knew he was shooting at a human being because he mistakenly believed he was facing a threat from that person, that might be imperfect self-defense. It's not insanity.
I submit, ladies and gentlemen, that his unique psychiatric history, the fact that the majority of threats were directed at him and his business, and the fact that he was the sole person responsible, puts him in a much different category. And when you're discussing his mental state and what effect these things had on him, don't go with Schlesinger's general statement that, well, the other people were afraid too. Totally different. No one else, ladies and gentlemen, were calling people to try to get help, like Michael Barisone was. No one fled his own home. No one hired a private investigator to do background checks on them.
Too
No one
late.
spent
Should have done that before you invited them to live on your property.
Think about this. When the prosecutor maybe comes up with some cockamamie story with regards to a financial issue or problem, Steve Tarshis testified that Barisone was worth millions. No one else filed a complaint with Safe Sport against Cataract. Now, I'm sure the prosecutor is going to make some argument with regards to why this happened. If the prosecutor suggests to you that the motive is that Michael Barisone thought a complaint was going to be made against him with Safe Sport, and that's the reason why he wanted to kill Lauren Cataract, then when he says those words, I want you to think, well, Michael Barisone filed a complaint against Lauren Cataract. Does she have a motive to kill him? You can't have it both ways. That's what I'm saying. Think about everything that's said to you.
The notion that because she filed a civil case against Michael Barisone, that Lauren Cataract filed a civil case against Michael Barisone, means she had a motive to kill him. She doesn't want him dead if she's filed a civil suit.
No one else called 911 on 4 separate occasions.
To put it another way, if she kills him, that's going to complicate her civil suit.
No one else was turned away and felt as helpless when the police and the Morris County Prosecutor's Office wouldn't help him.
All of this could be true. It's still not insanity. He felt helpless because no one would help him deal with this crazy woman he invited to live on his property. That sounds like a Michael Barisone problem, not a you get to shoot the people who are being mean to you problem. And it's not insanity. And it's not self-defense.
Didn't even want to look at the documents, the things that he had masked in this investigation that he was doing on Cataract. He even personally went to the Washington Township Police Department and tried to plead with them for help. What impact would that have on someone different than everyone else? When you call the people that are supposed to protect you and they do nothing.
The police have no role in protecting you from your poor decision-making. You invited a lunatic and her boyfriend to live on your property. That's not a police problem. That's a you problem. Jeepers.
What impact does that have on someone's state of mind? He also hired a personal security guard, Mr. Davison, to sit excuse me, in his truck to guard the stable area. I submit he had a lawyer write letters and serve a complaint. That coupled with all the things that Cataract was doing specifically to him puts him in a unique category that you should consider. Remember, what was Cataract's motivation? She admitted to a plan to destroy him and the business. That plan included attacking him on social media.
Mean, not grounds for shooting her.
Accusing him falsely of neglecting horses, insurance fraud, falsely claiming bullying and threatening her life.
Again, mean, not grounds for shooting her.
She had a plan to scare him. Remember the text that that I questioned her about? We have to scare Michael Barisone.
Mean, not grounds for shooting her.
And then the various texts after that, where she's talking about Michael Barisone being scared. Totally different circumstances.
All of that's very mean, not not legal grounds for shooting her. Now, frankly, it could have been grounds for a civil complaint, some intentional infliction of emotional distress, a civil complaint brought by Barisone against her, against Lauren Canarak. I can see that. I mean, civil work is not my area of expertise, but that seems like a viable cause of action to me. But that's where being mean gets settled in civil court, not by shooting somebody.
I submit that she had a plan to cause him to flee his own house by scaring him, talking about weapons incessantly, sleeping with a gun underneath her pillow, having 2 guns, 2 9mm guns.
So, I mean, to many of us, this argument that, maybe she had reason to be scared of Michael Barisone. That's why she was sleeping with a gun under her pillow. And this notion that she had 2 guns, 2 9mm guns. To some of us, we might be wondering, why in the world would he mention that? I mean, I can assure you, I have far more than 2 9mm guns. But this is New Jersey. It's a gun control state. Many of the people have been, psychologically brainwashed into imagining guns as if they were live rattlesnakes found in your bed under the covers when you go to bed at night. So the mere mention of the word gun could have a psychologically influential effect upon members of the jury, which is ridiculous, of course, but that's what happens when people are subject to brainwashing for decades of their lives.
Talking about killing the king, sacrificing the queen, destroying the castle, talking incessantly about going to war. It's time. War's inevitable. Why would anyone say those things unless they were trying to drive someone over the edge?
Yeah, okay, so fair enough. They were trying to drive him over the edge. But that's not the question here. If the legal defense is insanity, the question is, was he over the edge to the point where he did not know? He thought he was shooting a werewolf or a Martian or a robot or a witch. He did not know he was shooting a human being. The question is not what they were trying to do. The question is, what was his actual state of mind in the moment he pressed that trigger?
But possible.
What matters is not what they were trying to do, unless you're going for that not legal defense, but emotional defense of these people are such horrible monsters. You should acquit my client because of how horrible they are, which could work.
Legitimate purpose would they have attacking him like that? She knew he was emotionally unstable. She knew she was scaring him. She knew that all the things that she was doing, like posting his own words and
yeah, so this is all she earned it argument. She had it coming argument. She's a witch and a horrible person and malicious and vile and nasty. And no one should have to deal with the kind of hate that flowed from a woman like this. And it shouldn't surprise anyone that he shot her because she had it coming. Those are not legal arguments, but those are emotional arguments that might be compelling to the jury.
taunting him with them would cause him to go insane. Why would someone do that? Take private conversations and use them against that individual. What effect would that?
I mean, it'll be interesting to hear the state closing, Because if I were the state, I mean, I would get right up there and say, listen, this woman, Lauren Canarak, she's a witch. She's horrible. I wouldn't want to have to deal with her in my personal life. It must have been a nightmare. But none of that matters. None of that justifies him shooting her. And remember, it's only pure luck that these two people are not actually dead. But I would concede the witch aspect of the victims here right up front.
Have on someone who's becoming emotionally unstable? Does he think he's hearing voices? Does he think everything that he says is being recorded? Is that a rational assumption? Does he know for sure? What effect would that have on someone's mental state? And there's testimony that the majority of that taunting was directed specifically towards him. What would it take for someone to leave their own home? Think about that. What would it take for someone to flee their own home? What effect did Canarak and Goodwin and the father have on kicking him out of the place that he fled to, the stable area?
About 15 minutes to go, folks.
He's now sleeping on a couch, living out of a suitcase in the stable area. She made him homeless. And someone may think or argue, well, you could have just gone to a hotel. That's what one of the town people said. He can't leave his property. He's afraid that Lauren Canarak, Goodwin, and the father are going to destroy his business. People are afraid that they're going to burn down the barn or hurt their horses. Why is Cox sleeping in front of her horse in the stables? He can't leave all this. This is what he built up from nothing, ladies and gentlemen. He's already fled his house. Do you think it's realistic to think?
Well, he can leave. He can, or he cannot. That's up to him. But what he's not allowed to do is shoot somebody over it.
That he would just leave the property and leave it to Canarak, Goodwin, and the father? You heard testimony from numerous witnesses that he wasn't sleeping. He was wandering the property at night, trying to protect everyone. Who does that? And finally, there's evidence that Canarak set forth steps to have DCPP come onto the property. Barisone told all the experts, the defense and the state expert, that he overheard her talking about sexual misconduct. And that's when he had the breakdown. What's odd, based on Dr. Schlesinger's testimony,
You know, and I expect, so yeah, of course he should have tried to evict her legally, which he never actually did. I mean, he gave her a pro forma eviction notice just before the shooting happened, but it was never even filed to court. So that was never a proceeding actually in place. But I bet he didn't even have any kind of rental or lease agreement with this woman. None. He didn't do a background check on her before he invited her to live on the property. And if you don't have a written agreement where you can point to an explicit violation of the terms of that tenant agreement to get someone evicted, man, it's going to be a long, hard slog to get rid of that tenant, because tenants have rights too. And it's all loosey-goosey argument if there's no contractual arrangement in place. And I bet there wasn't, because I haven't heard any mention of any throughout this entire trial.
is that no one, including Schlesinger, is saying
He can't call the police for trespassing. I guess you can call him for trespassing, but he can't enforce a trespassing complaint because they have a right to be there. They were invited to live there. They're lawfully present until they're explicitly evicted by a court order.
that Michael Barisone is faking his physical and psychological deterioration in the days leading up to the incident. Numerous people took this stand, put their hand on the Bible, and testified to Michael Barisone's decline and failing mental state prior to the incident. It's not something we're setting forth after the fact, prior to the incident. And the prosecutor could have.
Yes, having a rental or lease agreement doesn't mean it's easy to get rid of a tenant. It can still be incredibly difficult. But it doesn't get any easier if you don't have the written contract.
Told all these people if he wanted to give you the real picture. All of those witnesses, and I think I put on 23, 24 different people. All of them testified to various observations they made about his decline. Some of them were graphic. I'll name a few. Not sleeping, not bathing, eating, wandering the property at night, unable to carry on a conversation, incapable of handling simple business affairs, crying, sobbing hysterically in a fetal position. Those people compared Barisone before and after Lauren Canarak's attacks. He went from this confident, elegant, dignified man to a distraught, disheveled person, pacing aimlessly, mumbling to himself, was described as catatonic. If you recall, the town official, Ms. Gibbs Cook, said on the 6th she could barely recognize who he was from how she had known him before. She described him as undone. Her words. Many of those people who had known him for years, in seeing this decline, thought he was going to kill himself. And numerous people, Olympic athletes, testified that they called and they tried to console him. He was unconsolable. All because of Canarak, Goodwin, and the father's attacks. Justin Hardin, who was a state's witness, who has known Michael Barisone for 17 years, described him as out of his mind. Others testified he was unable to function. The one thing Justin Hardin said, which to me hits home, is Michael Barisone's love for horses, love for riding. He stopped riding. He stopped teaching, training people in horses. That speaks volume as to his mental decline. All these people testified as to Michael Barisone's systematic destruction of him, all at the hands of Canarak. It was her plan, and her plan worked. They drove him crazy. The state wants you to believe that Michael Barisone, after experiencing this level of deterioration, was capable, after the severe beating that he got from Robert Goodwin. After he was choked unconscious, how somehow miraculously he flipped a switch and had the presence of mind to make up a story. I don't remember the event. This is totally inconsistent with every piece of evidence that has been put before you. The prosecutor's going to suggest, I assume, that after all of this, that Michael Barisone should be taken with regards to his statements as an admission of his guilt. When he starts talking about that, recall all the evidence of his mental state when these statements were allegedly made. I submit, ladies and gentlemen, that every single person, the police officers, the medical people that were treating him, everyone had indicated that when Michael Barisone was asked about the events, he had no recollection.
Okay.
So his rambling statements, I had a good life, they destroyed my life. What does that mean? Under those circumstances, in his condition, I submitted the ramblings from a man suffering from a mental breakdown, a man who's delusional. What's outrageous, ladies and gentlemen, is the prosecutor's attempt to argue that
a mental breakdown is not insanity, defense folks. Those are two different thresholds. So someone can have, the law treats a mental breakdown, using force unlawfully, but under circumstances of what the law calls adequate provocation. You were taunted, you were tortured, you found out your wife is cheating on you, you were in a hot emotional mess. That's not an insanity defense. That's a mitigation defense. That's a diminished capacity. That's a heat of passion. That's a voluntary manslaughter instead of murder mitigation defense. You don't get acquitted. You get manslaughter instead of murder. That's not rising anywhere close to the point of, I did not know I was shooting a human being. I thought I was shooting a Martian.
Barisone's statement at the hospital, "I'm sorry," was an admission of guilt. That detective couldn't testify to the circumstances where the statement was made. Any context. He didn't even know the exact words. He said, well, words to the effect. What should concern you is that the detective didn't remember who was there, whether or not he was talking to anyone, and doesn't remember the exact words. I ask you to remember that with regard to that statement, "I'm sorry," it was not contained in his detailed notes that he took contemporaneous with everything that was going on. He also never put or testified on direct examination that before that statement, Michael Barisone was injected with 100 milligrams of fentanyl. Fentanyl. Prior to that statement. Why didn't the prosecutor bring that out? Isn't that important? Aren't those details something that you should consider?
Yeah, I wouldn't give too much weight, and I understand why the defense is attacking it, but to the extent someone says after a traumatic event, "I'm sorry," that could mean lots of things. That don't mean I think I'm guilty of a crime. It could be, "I'm sorry this happened. I wish it didn't have to happen. I wish there had been some other way." But that can all be consistent with innocence.
Before you're deciding whether or not that's an admission of guilt, don't you think you should have all the facts? And even though there is no burden on the defense, I don't need to do or say anything.
there is a burden on the defense. If you're arguing self-defense, insanity defense.
Don't you think things like that would be important in you assessing what that statement meant? Why is the defense constantly bringing out things differently than what's originally proposed to you? I ask you to recall also that that report was dated over 2 months later. Tried to explain that, well, the report, there's no evidence of that. You have his testimony. The next cop that took the stand, I asked him the same thing with regards to the date of the report, and he says that's when the report was written. What's going on here, ladies and gentlemen? And if you believe what every medical person said about Michael Barisone not remembering the specific incident, I submit you can't be sorry for something you don't remember. And again, this is the linchpin of the state's doctor's diagnosis. That's all he talked about. You have 2 doctors that the defense put on that address this issue, address, again, the concern of the state doctor that someone charged with a criminal defense may feign symptoms, may fake. Dr. Schlesinger never suggested that Barisone was faking the things that happened to him before the incident. He focused solely on the statement, I don't remember. Recall the actual testimony, the evidence. The first officer on the scene, Barisone's partially conscious. These aren't defense witnesses, although I had to bring it out. The second officer, incoherent. The third officer, I need to wake up. Is this real? Someone questioning their reality. Every medical person, and the prosecutor was not able to put one person on to dispute this. Every single medical person that talked to Michael Barisone said that he could not recall the event. They described him as confused and even said he was in an altered mental state. First aid, ambulance people, EMS, hospital personnel, and even the doctor at the jail days later said the same thing. If Michael Barisone wanted to lie about something to protect himself because he's tried with a criminal offense, don't you think, ladies and gentlemen, this bright, intelligent man could come up with something better? Use your
Doesn't look that
common
bright and
sense.
intelligent right now.
He could have made up a much better story. Cataract had a gun. I shot her. I was getting the hell beaten out of me. The dog was mauling me. I shot her in self-defense. Don't you think he could have come up with something better than I don't remember? That ties his hands. It doesn't help him.
Except if he'd made those claims, there would need to be evidence in support of those claims, or he's just lying. And lying doesn't help him either. She had a gun. Where's the gun?
It puts me in a position where I'm chasing windmills. Like,
Here's what happens when none of those alternative explanations are true or supported by evidence. Maybe you feel like you can't make those claims. Maybe that's why you fall back on the helpless, I just can't remember.
Don Quixote, I don't remember, doesn't help him. What it does, ladies and gentlemen, it gives you a basis to believe Dr. Simmering and Dr. Hassan.
If the camera had been working, what would the camera show? Would the camera show his insanity? Because they're not arguing self-defense here. They're arguing insanity defense. So how would the camera contribute to an insanity defense? Would it show him insane? Would it show the inside of his brain?
If that's not enough, I submit there's overwhelming evidence that that statement is truthful. Both Simmering and Hassan looked at that issue and believed and testified that that loss of memory is real and was either caused by the beating he took to his head or the psychological breakdown. Dr. Hassan even did specific psychological tests to test for feigning. Dr. Schlesinger never did those. Why not? Because it doesn't fit in with his scenario to help the prosecutor. But Dr. Hassan testified that he did those tests, and those tests indicated that there was no feigning. Dr. Schlesinger didn't take those results like Hassan did and say, oh, that's wrong, those are inaccurate. You can't throw out your common sense. You need to look at all the evidence. You need to rely on the most qualified and experienced experts with no agenda.
Oh,
In closing,
thank goodness.
I ask you to listen carefully to the judge's instruction on insanity.
So that's the defense, right? That's really the only legal defense he's making here, insanity. And what, maybe 10% of that extensive shouted closing would actually be relevant to the insanity defense argument, and frankly, not very robustly.
Once the defense establishes by the preponderance of the evidence, the state, as it always does, has the burden of proof beyond a reasonable doubt. That burden never shifts.
Okay, so this is kind of a deceptive description of all this, but he says once it's been established, the defense has been established by a preponderance of the evidence. If it's been established by a preponderance of the evidence, it wins, no matter what the state does. The state has its opportunity to disprove it by a preponderance of the evidence. In other words, more accurately, to prevent the defense from having proven insanity by a preponderance of the evidence. If the defense can prove insanity, convince the jury, it's more probable than not that this defendant did not know right from wrong, did not know he was shooting another human being, then they've won. I mean, that's an acquittal. There's nothing for the state to do in response to that. That's a successful legal defense on the grounds of insanity for the defense. But to say the burden's on the state, that's not quite right. The burden's on the defense to prove insanity by a preponderance of the evidence.
That is what this country, our legal system, is based upon. I submit, ladies and gentlemen, the defense has established clearly that Michael Barisone was insane at the time of the incident. He was suffering from a mental defect, a delusional disorder.
The defense expert did not say he did not know he was shooting a human being. The defense expert said he knew he was shooting a human being, but thought he was doing it in lawful self-defense. Well, that's not an insanity defense. That's imperfect self-defense. That's at best a mitigation from murder or attempted murder to manslaughter or attempted manslaughter.
And did not know the nature and quality of his actions, and did not know right from wrong. What Lauren Canarak, Robert Goodwin, and the father did to him was horrible.
That's true.
Horrible.
True. Not a legal defense.
They had a plan to destroy Michael Barisone.
True.
Don't let them use you to do the job, to finish the bastard. Find Michael Barisone not guilty. It is the right and just thing to do.
That's an emotional argument, not a legal argument. That's
Thank
the,
you,
they
counsel.
suck so
Ladies and
bad.
gentlemen, it's almost 11 o'clock. We'll take our morning recess, then we'll hear from Mr. Shellhorn for the state and his summation. Thank you. Please don't discuss the case.
All right. So really, in the end, a purely emotional argument, which really, I mean, I guess that's what he's got. So that's what he has to work with. So let's skip forward here and get to Shellhorn, Prosecutor Shellhorn, who, God willing, will not be shouting. He appears to be a non-shouter.
All right, be seated, everyone. All right, we're here now, the summation from the state. Go ahead, Mr. Shellhorn.
Thank you, Your Honor. May it please the court, counsel, members of the jury. Good morning. If you remember back to my opening statement 2 weeks ago, I told you that I was intentionally leaving things out. And that I was intentionally leaving things out because evidence doesn't come from me. It doesn't come from Mr. Belinkis, Mr. Deininger, Mr. Bennett. Evidence comes from witnesses. It comes from people who—
Oh, folks, I hate to say it, but it looks like this is going to be an hour. Sorry.
walk through that door, put their hand on the Bible, take the oath, and agree to testify. So no matter what Mr. Belinkis may have said in his closing, what I may say over the course of the next hour, that's not evidence. The evidence comes from the witnesses. And I start there because your verdict will be based on evidence. It's not going to be based on passion or sympathy or emotion. It will be based on evidence that you heard, evidence that you saw.
Yeah, so that defense, that emotional argument that wrapped everything up, that's really a jury nullification argument. Now, the lawyer's not allowed to say the words jury nullification. He's not allowed to argue the doctrine. Return a verdict contrary to the law, regardless of what the judge instructs you. I mean, he'd have his ass handed to him by the judge in a mistrial for sure, and maybe never practice law again. But instead, he does the soft version of that, which is say, acquit my client. It's the right thing to do.
Mr. Belinkis just spent an hour telling you what he thinks I think, what he thinks I'm going to argue. I hope that I won't leave any questions for you when I'm done. The verdict sheet that you're going to be given has one.
If there's a mistrial, it's up to the prosecution, up to the state, whether or not they want to try Michael Barisone again. He's subject to retrial if there's a mistrial in this case. But they can decide not to try him again if they want. It's up to them.
Person's name on it, and that's the defendant, Michael Barisone. He's the one person on trial. He's the one person that you're going to go back in that room and deliberate, not about whether you like or dislike Lauren Canarak, not whether you like or dislike Rob Goodwin.
Right. So this looks like this prosecutor Shellhorn is taking the attack I would have suggested he take, which is, Lauren Canarak and Robert Goodwin suck. They are horrible, monster, vile people. But the legal question here is not whether or not you like them. There's only one person on trial here. It's not Lauren Canarak and it's not Robert Goodwin. It's Michael Barisone. Was he justified or excused, legally justified or legally excused, in shooting Lauren Canarak twice in the chest and shooting at Robert Goodwin in an attempt to kill them?
Not whether you like or dislike me or Mr. Belinkis, or frankly, whether you like or dislike even the defendant. The verdict sheet is going to ask you whether the defendant is guilty, not guilty, or not guilty by reason of insanity. Over the course of the next hour, I'm not going to tell you what to think. I'm not going to tell you what to feel. I'm going to point out things that I think the evidence shows, that I think the evidence will help you to decide this case. I don't have any remarkable catchphrases for you. I'm not going to cry. I'm just going to ask you to follow the facts and apply the law. Now, when you all got your jury summons several months ago, you were told what to do, when to log onto your computer, when to have your camera on, when to turn your camera off, when to be in the courthouse, what time to be here, where to go, when you can take a break, when you can talk to people, what you can talk to them about, what you can't. But the one thing that no jury is ever told is how to deliberate. When you go back through that door after Judge Taylor gives you the law, how do you apply the facts and the evidence that you heard to the law the judge is going to give you? So I hope that over the course of this closing argument, I'm going to give
I would
you
say you
something to
applied the
frame.
law to the facts,
You
not the
can
facts
use
to
it,
the law.
you can
but
ignore
whatever.
it, but hopefully it will give you a logical starting point for how to examine those facts and how to apply them to the law. Mr. Belinkis ended his closing by pointing out those burdens of proof. And if you remember back to my opening statement, I told you, the burden of proving the defendant guilty rests with Mr. Bennett, it rests with me, it never shifts. That's our burden to prove that the defendant is guilty of attempted murder and of possession of a weapon for an unlawful purpose. So that's where I'm going to suggest that you start your deliberations. But you're also going to hear the judge tell you that the defendant is claiming insanity in this case, and that the burden of proving insanity is on the defendant to prove.
Boom. Told you, folks. Told ya. Actually, you could have just looked at the statute, lawselfdefense.com/NJ insanity for the New Jersey insanity statute. Tells you right there, burden is by a preponderance and it's on the defense. So yes, the state has to prove that the defendant shot Lauren Canarak and shot at Robert Goodwin and was in unlawful possession of that gun beyond a reasonable doubt. But frankly, that's not going to be hard to do here. And then if the defense wants to raise a legal defense of insanity, the defense has to prove insanity by a preponderance of the evidence.
That's his burden. So I'll suggest that you address that second. Now, with respect to attempted murder, the judge is going to tell you that a person's use of a deadly weapon allows you to infer that their purpose was to cause death. The reason I start there is because that is such an important part of this case. Why did the defendant use the weapon that he used?
If you just joined this from the start, folks,
It may seem
it's hard for me. I don't know in the comments what part of this live show you're in, but if you're just joining from the start, the first 5 or so minutes of it, I was on webcam microphone by accident, and that's the poor audio quality. But I was finally informed of that. Thank you very much to the chat, and switched over to the good microphone. Sorry about that.
It seems simple, it may seem basic, but I'm starting there because he didn't use something that was in his pockets. He didn't use his belt. He didn't use his fists. You heard about the search of his truck. You heard about some of the things that were in the truck, the shovel, the tire iron, things that when he drove to the house were there in the truck with him. You heard about the patio area. There was a rake there, there's flower pots, there's chairs. There are a number of other things that he could have picked up in that moment. And yet when he got into his truck, when he drove to confront Robin Lauren, he went there with a deadly weapon. He picked that deadly weapon before he even got in the truck, before he even drove to the house, before he even got out of the car. He had picked that specific deadly weapon. This is the gun. This is the gun that he picked out of his safe to use. And I point that out because you heard testimony.
So it's an interesting question in the comments. If he's too insane to be guilty of attempted murder, is he too insane to be guilty of illegally having a gun? And I suppose that theoretically could be an argument, except that he used it as a gun. So he knew it was a gun. If they'd caught him unlawfully in possession of a gun and he was trying to eat soup with it, maybe he'd have an insanity defense to the possession of the gun charge. But if he's using it as a gun, he clearly knows it's a gun.
You heard evidence that he had his own guns. He had a .380 caliber, semi-automatic, bless you, handgun in his safe. But what did you hear about that gun? There's no firing pin, there's no extractor, there was no ammunition for that gun. That gun was not an option. You heard about the .45 revolver. But again, you heard that that gun was in the safe but there was no ammunition for that gun either. And lastly, you heard about his .22 single action antique revolver. The importance of that being a single action, if you remember the testimony, and if you're not familiar with guns, is that in order for him to fire a shot, you would have to use your thumb to pull that hammer back, to prime it, to get it ready. And then pulling the trigger would shoot a bullet. But to shoot a second bullet, you would have to pull the hammer back again and pull the trigger again.
Which can be
So
done
for
pretty
each
quick.
successive shot, you would have had to pull the hammer back and then shoot. You also heard about the way revolvers are loaded, that you don't just put all the bullets in at once, that you have to actually turn the cylinder and put the bullet in, and turn the cylinder again and put the bullet in. It takes longer to load. And that gun, for example, only held 6 bullets. Compare that to the gun he did use. Ruth Cox, 9mm, small, had 2 magazines, one of which was loaded with bullets. And it,
So, so now the prosecutor is going to talk about all kinds of scary gun stuff to frighten the jury, a New Jersey jury that presumably thinks that guns are live rattlesnakes and being thrown at them. So he's going to talk about the magazine had bullets in it, and there was a round in the chamber, and blah 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 blah. None of this is all that really matters for legal purposes. Is that Barisone knew it was a gun and discharged it at Lauren Canarak and Robert Goodwin. The rest of how many rounds were in the gun, how many rounds another gun can hold. The revolver can only hold 6 rounds, and this one can hold whatever, 8, 9, 10. None of that has any legal significance, but it might make the gun appear scarier on an emotional level to the jury. Frankly, I think it's inappropriate argument, but it's the kind of argument that you would make when you're dealing with a jury that may well have been brainwashed their entire lives to think that guns are some kind of inherently terrifying object.
and put into his pocket, making sure that he was taking more ammunition for that deadly weapon with him.
Now, his firearm terminology is not accurate. He said pulling back the hammer of a revolver is priming it. That's not what priming means.
To the scene. Do you recall when the safe was searched later that day? This is what it looked like. The case where the handgun was, the case that Ruth Cox gave it to him in, with that orange safety magazine in it. The orange safety magazine is out.
By the way, worth mentioning here, notice, folks, they went into his safe. They got into his safe. And I don't know if he gave them the combination, but if they didn't give them the combination, they'd get a warrant and break open the safe to get into it. And this shooting did not happen adjacent to the safe or even in his home where the safe was located. It happened outside. So wherever you are, when you get involved in a self-defense shooting, heaven forbid, you ought to presume that the authorities will be going into your safe. And if there's stuff in there you'd rather the authorities were not aware of, they will soon be aware of it.
The 2 magazines are gone, and there's a box of 9mm ammunition right below the gun, open and with bullets missing.
What
Why is
matters,
this
it's
important?
open.
Because the judge is going to tell you that just based on the fact that the defendant used a deadly weapon, you can infer that his purpose was to take a life. And he didn't pick up this deadly weapon when he first saw Lauren. He didn't pick it up when he first saw Rob. He didn't pick it up when he first got out of the truck or when he first drove there. He picked it up in the office out of his own safe. He knew when he opened the safe and took that gun exactly what he was going to do. His possession of that gun wasn't accidental, it wasn't incidental, it was purposeful. Now that
Seems likely
inference
enough.
again is important because the judge is going to tell you a number of things about the law with respect to attempted murder. But he's going to tell you that essentially Mr. Bennett and I have to prove 2 things to you. First, we have to prove that the defendant's purpose was to cause the deaths of Lauren Canarak and Rob Goodwin. And second, that he did something that's what's called a substantial step. Again, I'm going to discuss why the evidence shows that the defendant is guilty of this crime. Do you recall where the shooting happened? I'm sure you do. You heard a lot of testimony about it. It didn't happen in the defendant's office.
I'm speeding
It
this
didn't
part
happen
up,
in the
folks,
barn.
because this
It
is
didn't
the
happen at
shooting
one of these
itself
times
is
where
really
Lauren Kenrick was
uncontroverted.
supposedly creeping around and sneaking behind bushes and popping out of the dark. It didn't happen when the defendant just happened to come in contact with her. In fact, you heard testimony that the defendant and Lauren Kenrick had not even seen each other on August 7th. Everything that was going on between them in this week leading up, and on the day that he's charged with trying to kill her, they hadn't even seen each other that day until he went to find her. That's important because Ruth Cox gave the defendant that gun in the stables. And she said that she saw him take that gun back into the clubhouse in the direction of the office, the same place that we just saw where the gun case was found, where the orange safety magazine was found. The gun was in the office, it was in the safe, at the barn. The defendant was last seen in the office at the barn. And yet the shooting happened all the way a quarter of a mile up and down by the farmhouse, a place where the defendant had gotten into his truck and driven to. Before I talk more about the elements of this crime, I do want to discuss credibility. You heard a lot about the credibility of the witnesses. And basically, Mr. Belinkis said, you can't convict the defendant because the only evidence that he's guilty comes from two liars. Two, I think he said, despicable people. They can't be believed. Well, the judge is going to tell you that you're the sole judges of the facts. You decide credibility, not Mr. Belinkis, not me, not the judge. It's you, the deliberating jurors. And that you do that just the same way you do every single day of your lives. You talk to your spouse, you talk to your kids, you talk to your parents, coworkers, friends. You're evaluating, is what this person telling me reasonable? Is it likely? Is it probable?
Is it corroborated?
Lauren Kenrick had 2 bullet holes in her chest.
That's the corroboration.
You saw the clothing. There were bullet holes in the clothing. You heard about the testimony about the bullet holes, the bullet hole in the side of the house. And Mr. Belinkis said Lauren Kenrick was shot twice in the chest, and that, like in a cartoon, one of those bullets was able to go out her back and somehow curve up and go out through the top of the house. Does that sound reasonable or probable or likely to you? You heard the testimony, and again, you'll have these exhibits for your deliberations about where that reconstruction showed that the gun had been shot, that it came in through this door, grazed across this mat, and came at an upward angle through the back window. And if you remember, with the diagram, that basically shows that the gun was shot somewhere in the area of where that bush was. Physical evidence, uncontradicted by anything, that corroborates what Rob and Lauren testified to. You heard about the state of the gun, that when Corporal Heimer gets on scene and he pulls in and he sees 2 men struggling on the ground and he sees a woman bleeding and he rolls the defendant over, and underneath the defendant, not on the ground like Mr. Belinkis would have you believe, underneath 6'4" Michael Barisone's body is the gun. That Rob Goodwin is literally struggling for his life. I'm not exaggerating. That's not hyperbole. I'm not just saying that to make you feel emotional. You heard the 911 call. The 911 call where Rob Goodwin is saying, are you sending anyone? Are you sending help? Hold on, he's moving, he's moving. If you move again, I'll break your arm. His arm isn't broken at that point. Rob Goodwin is saying that while the 911 call is still connected. And then when Corporal Heimer comes in and sees this scene and rolls the defendant over and finds the gun just like that, just like Rob Goodwin testified, when I looked back, I saw the slide was back because the gun was out of bullets. And I was just holding him on the ground, waiting for someone to get there. And Corporal Heimer, who's working a road, third-party road detail or whatever he called it, gets a call that there's an active shooter at this property. And he pulls in by himself, and he says he can't see what's going on in the backyard. There's a huge dually, a big silver pickup truck in the way. And he comes around, and he's got his gun out. He doesn't know what exactly he's going to encounter. And he sees a woman bleeding. And he sees another man saying, this is the shooter, holding him down. And he pulls him off, and he finds a gun underneath his body, and he takes the magazine out and he throws it. And what does Corporal Heimer say? Not Rob Goodwin, saying, if you move, I'll fucking kill you. That's Corporal Heimer saying that, and it's all recorded. You heard it all on the 911 call, which corroborates everything that Rob and Lauren said happened. This attack didn't somehow happen before the 911 call. And then I guess they had time to walk around and plant evidence in certain places, plant a cell phone in a certain place. Do you remember where the defendant's cell phone was? It's on this table, right here. The exact place where Rob Goodwin and Lauren Kenrick say that they see the defendant. Both of them testified they didn't see him get out of the car. They didn't see when he walked over behind that bush to hide himself behind the bush. They couldn't see if he had anything in his hands. And yet Mr. Belinkis would have you believe that after the shooting happens, that after they beat up Michael Barisone, they're going around planting cell phones in different places. What else did you hear about the scene? Corroborating what Lauren and Rob said. Well, emergency personnel are showing up. Corporal Heimer is there, Officer Wurtenberg's there, Officer Hensley's there, and now it is a free-for-all. There are officers there, there are multiple ambulances there, they're trying to separate people. Isn't it more probable and likely and satisfying to you that somebody moved those cell phones and put them at the base of the umbrella, not Rob Goodwin or Lauren Kenrack? You heard about the weather that day. You heard about the fact that within about an hour of this shooting happening, that the skies opened up, and you saw the pictures. You don't have.
I don't think Barisone should have testified. I don't know what he would have added, frankly. And of course, he would have subjected himself to impeachment. And who knows what he might have opened the door to. And frankly, if you really think your client's crazy, are you going to put him on the witness stand? No. I mean, again, I remember he says he has no recollection of the key events. So what would he contribute exactly? And there's always a risk he's going to come across as just a faker. So no, I don't think I would have put him on the witness stand. If he'd had a recollection of events and it actually looked like a self-defense case, then yeah, I probably would have put him on the witness stand.
Have to take anybody's word for that. You saw pictures of evidence that's literally in inches of standing water because the rain came down so fast and so hard. And Mr. Belinkis says, well, they didn't look for fingerprints on the soaking wet shell casings. They didn't look for fingerprints on this or that. He said they didn't look for gunshot residue. You heard that they looked at the clothing and that it was all soaking wet. You heard that that's a tool that they use. It doesn't show definitively who the shooter is or who the shooter is not. It's a tool that they could possibly use. So back to Lauren Kenrack and Rob Goodwin. Back to credibility. Would it be more satisfying to you if Lauren Kenrack came through that door, came in here, Mr. Belinkis held this up, put her hand on this and said, I'll tell the truth. And then Rob Goodwin said the same. And then they testified to exactly the same words, exactly the same things. Would you feel like that was rehearsed? Like that was fake? Like that was made up?
Yeah, I mean, fair point. I frequently make this point myself. It's because nobody knows what happened in any absolute sense. Everyone at best can only be sharing their personal perspective of what happened. We all know if you take 5 eyewitnesses to an event and you separate them, you get 5 variations of the story. And hopefully the variations, if they're telling the truth, the variations will be largely consistent on the key substantive elements of what happened. You know they're going to vary on the details because the way the mind captures and stores and recalls information is it places greater weight on the essential elements and not so much on the details. But even in the essential elements, there can be varied memories and the people are still telling the truth. You put them on a lie detector, they'd pass. They think they're telling the truth. It's just memory is defective. Recollection is defective. The way we perceive things is defective. So if you had 5 eyewitnesses and they all said exactly the same thing, you'd figure that was rigged.
Or do you find it more satisfying that in this unexpected moment, and I'll get to the defendant's state of mind and his emotional state in a moment, but they won't describe that he gets there and he's calm. They can't see him, he's hiding behind the bush, and he says words to the effect of how can.
Yeah, and I see somebody in the comments mentioning the Curtis Reeves case. In the Curtis Reeves case, the police were questioning witnesses together, which runs the risk of what's called witness contamination. This was talked about quite a bit in the Curtis Reeves trial, where witness A and witness B, witness A is questions first, but in the presence of witness B will conform their later answers, or may conform their later answers, to what they heard witness A said. And so witness B's testimony is now contaminated by the earlier statement by witness A that was overheard by witness B. That's why you want to separate the witnesses. One of several
And
reasons.
we end this without a war. And Lauren Kenrack comes down off the step to talk to him. Then he lifts up a gun and he points the gun. And when she's no closer than I am to Mr. Belinkis, he starts shooting her in the chest. And Mr. Belinkis says, well, you can't believe anything she says, because at that point, when her body cavities, her torso is literally filling up with blood, her lungs are punctured. You heard that testimony, and her body is filling with her blood as it's pumping, not into her veins, but into her body. And she feels like It's an eternity. You heard her on the 911 call. Was that fake? Was she acting? I've been shot in the heart. Help me. Michael Barisone shot me in the heart. Was that fake? And then Mr. Billingis
I know
did
Massapequa well,
when he walked all
Paul. I
around
used
the
to live on
courtroom
Long
and showed
Island.
everything that he thought that Ms. Canarac was testifying about what she did. I don't remember her reenacting that for us. I don't remember her doing all that. It's your recollection that it controls. That's Mr. Billingis' version of what she testified to. If you think
I'll
about what
be
she
in
actually testified to, she said, "I
Asheroken
didn't know where I went.
by Northport
This
this
is
summer,
weird. I walked
visiting my
around
dad.
and patting my chest. She didn't believe that she had actually been shot in that moment. And Rob Goodwin, again in that moment, is struggling for his life. He sees the gun, that picture that we saw where the slide is locked back because it's out of bullets, and he's fighting for his life. And he's just trying to hold the defendant down until police get there. Doesn't all of that corroborate what Lauren and Rob said? The last thing I'll mention is the dog. You heard a ton about the dog in this
Rosie
case.
the dog.
You heard the dog. You heard this vicious, you heard Cujo barking on the 911 call.
That was an
Barking,
overreach by the defense.
Yapping. I can tell you when I'm wrestling with my kids, and if the dog is there, the dog jumps in, and the dog is not Cujo. I don't have a vicious junkyard dog. But my dog has a tendency to jump in there and kind of start nipping and getting into the mix with us. Isn't it more logical and probable and reasonable to think that after the defendant had just shot Lauren Kennery, taken a shot at Rob Goodwin, and Rob Goodwin is literally struggling for his life, that's when these dog bites occur? Now, the issue of credibility doesn't just apply to Lauren Kennery and Rob Goodwin. It applies to every witness. So every witness who came in here is subject to you considering, are they worthy of your belief or not? Did they testify?
Look at
when we went
Belinkis.
to deceive you? Were they evasive? in their
Belinkis is like falling
questions?
asleep.
Now, you heard testimony or an argument from Mr. Belinkis about Stephen Tarshis. And I'm sure you all remember when Mr. Tarshis testified.
What is Belinkis making notes
My
about? He's
impressions of
done.
Mr. Tarshis are that he was very prepared. He
I
was
guess
very
making
professional.
notes for
He was
appeal.
very knowledgeable about what was going on. And I would submit to you that it was not a mistake that he didn't say anything, not a word on direct examination about that eviction complaint being fake. Mr. Belinkis brought out everything he brought out. He's such a great cross-examiner that he got the truth out for you. Do you remember when Mr. Tarshis testified? Mr. Tarshis testified that on August 5th, he sent a letter to Lauren Kenneth. He sent a letter that basically said, things aren't working out here. You need to leave. He said that letter wasn't signed. And he was asked the question on direct examination, did you send a signed copy to her too? And he said, yes. Then he was shown a verified complaint. That's what he called it, verified complaint. He said, yes, I sent this through a courier service or something of that nature on August 6th to Lauren Kennery. I sent her that eviction notice. That was all the testimony you heard about it on direct examination. And it wasn't until cross-examination when he was shown a copy of that verified eviction complaint that he said, well, this was never signed. That wasn't real. Michael Barisone wanted me to send that to scare her into leaving. The man whose defense in this case is that he was crippled by a delusion of fear, such that he had to go and kill or be killed. This same man is telling his lawyer to send Lauren Kennery a fake eviction notice to scare her to leave. And then that witness left that detail out when he testified on direct examination. You have to question everything that every witness said, not just Lauren Kennery, not just Robert Goodwin.
From the super chats, yes. Insanity Pepper, I had Mr. Super Chat. Insanity Pepper asks, to nullify a jury, you don't need a reason, right? You can tell the other jurors, I'm saying not guilty just because. You don't even have to say just because. During the deliberations, you just say, I'm voting not guilty, period. And there's nothing anybody can do to change your mind. Now, the judge will have instructed you, you're supposed to keep an open mind and discuss and debate with the other jurors. But the truth is, if in your mind you don't want to vote guilty, there's not a force on the planet Earth that can make you do that. If you have the willpower to sustain your position. If you're doing that for purposes of jury nullification, quote unquote, I wouldn't say those words out loud, jury nullification, but as long as you don't, nobody knows. Entirely up to you.
So the defendant is telling his lawyer, send her a fake eviction. you remember when Mary Haskins Gray testified? And I asked her about some of the text messages that she was exchanging back and forth with Michael Barisone in this week leading up. And there was a text message that she had sent to him. It's in evidence. You'll have it for deliberations. Can we please just tell them to leave? Still, no one has told them to leave. And his response was Monday morning. I'll take care of it Monday morning. Meanwhile, he's talking to his attorney behind the scenes. Send her a fake eviction notice. Let's try and scare her to leave the property. And the question was asked, who would do this? Mr. Belinkis said that about Lauren Canterac over and over and over. Who would do this? Who would do this? He screamed. The defendant is doing the exact same thing to her. What was going on at 411 West Mill Road in August of 2019 is not hard to understand. It's based on emotion. And you all know that because you have life experience. I'm sure you've had disputes with people, disagreements, whether it's at your job, whether it's with a family member, it's at school. You understand how some of these politics work. People don't necessarily want to address something face to face. And so they do it through back channels. So what was going on at this farm, you may not know all of the ins and outs. I think Mr. Tarshish said that the equestrian community was kind of incestuous. So you may not know all the ins and outs of the dressage community. But what was going on there is no different than things that we've all experienced at various points in our life. So take, for example, that there are various levels of rider. You have people like Mary DeFranco, who has the means, she has the wherewithal, the ability to own horses, to own a number of horses, to keep them at farms. She can take off from work for weeks at a time, travel to the farm, go train there. And she basically said she does it as a hobby.
Nice.
She enjoys doing that. And then you have someone like Stephen Tarshish, who testified, he's more of an enthusiast. He likes to ride, he said, 5 days a week, 15 hours a week. He said he competes in competitions, but he's also realistic about his capabilities, about his limitations. He knows he's not going to ride in the Olympics, but he just loves it. Then you have people like Lauren Canterac and Mary Haskins Gray. These are riders who are training because they do have aspirations to get to those higher levels. And I think you heard Lauren testify. One of the reasons that she didn't really want to or like working with Mary Haskins is because she felt like they were sort of too much of peers. They were too competitive. She wanted a trainer, somebody who had been there, who had been to those highest levels, someone she wouldn't be in direct competition with. And that was one of the reasons she didn't want to work with Mary Haskins. But you have these people who they do have those aspirations to get to the higher levels. And then at the very top of the sport, you have the people who have been there. Boyd Martin, Philip Dutton, Allison Brock, the Olympians, the Grand Prix, creme de la creme, the internationally known riders. And they all came in and they testified for Michael Barisone. They said, we accomplished those things because of this man, because he helped us get to that level. These are his friends. Lauren Canterac testified that one of the issues that was going on in that week leading up to the shooting is that her career, her riding career, was being threatened. And the very people that the defendant calls to testify in his defense are the elite. They're the people who are at the top, the people with influence, the people with power. And they're here testifying in his attempted murder case about what a great guy he is. He's legendary, he's brilliant, remarkable. Mr. Boyd said, I love the guy. The defendant is sending Mary Haskins text messages that says, I will get her a lifetime ban. He is out to destroy her ability to compete in this sport. And then the people that he calls to testify sit on the USEF board of directors. The same agency that the day before the shooting, Mary Haskins is going to the UPS store, making copies of 750 some pages of bad information about Lauren Canterac, putting in the overnight mail and sending to the USEF.
Well, of course, this really undercuts the, she's a witch argument and you should acquit my client on that basis. This makes it appear much more like tit for tat. Like they're both a-holes and both deserve each other.
Who would do this? Who would do this? Apparently, it wasn't just Lauren Canterac. The defendant was doing the same things to her. Now, I said before, this wasn't a random shooting. This wasn't just the defendant happening to come across Rob and Lauren in a dark part of the property. And I know that Mr. Belinkus pointed out, well, you had people like Mike McGrain testify, and Mike McGrain said, oh yeah, there was one time that Lauren Kennerak was dressed like a ninja, and she came jumping out of the dark at me, and she had no shoes on, and she had all black on, and it was terrifying. And then I pointed out, the day that this shooting happened, he never said a word about it. He never said a word. Does that make any sense to you? Is that at all satisfying? There's no question these people were not getting along. I am not asking you to go back and deliberate and think that it wasn't on both sides. You heard about all the Facebook posts. You heard about calls to the town. You heard about calls to 911. You heard about the police coming, the town coming, reports to the USEF, reports to Safe Sport. This is two groups of people that are not getting along and do not like each other. But that's not a delusion. When the defendant went to confront Lauren and Rob that day, he was acting impulsively. He was acting emotionally, but he was acting purposely. And that's the standard for attempted murder, whether or not the defendant acted with purpose. Did he surrender his restraint to impulse and to emotion? And did he act in that moment without stopping to think? Yes.
Right, but acting emotionally is not acting insanely. Those are two different things. If you know what you're doing, I mean, listen, killers are often making suboptimal decisions because they're driven by their emotions. That doesn't make their killing of the other person insane. It's common for emotionally driven people to kill each other. It's just murder.
There's no question about that. That is what the evidence shows. But the evidence doesn't in any way show that Lauren Kennerak and Rob Goodwin lied about when the defendant got out of the car and was holding a gun and pointed it at them and shot at them. And I would submit that the evidence shows the defendant is guilty of those crimes. Now, the second part of where I'm going to suggest that you go during your deliberations is with respect to the defense of insanity.
All right, here we go. So we've been arguing here whether, so far the state's been arguing that it's met its burden for the underlying crime. And frankly, it's been pretty clear throughout the trial that it has. Again, insanity defense, like self-defense, is a defense of confession and avoidance. You're not denying you fired the shots, you're conceding you fired the shots, but in self-defense, you're justifying that conduct as lawful because of self-defense. And in insanity defense, you're arguing that the firing of the shots, while nominally unlawful, should be excused for purposes of criminal liability because you were legally insane. So the state here has just buttressed its claim that, all right, this guy fired the shots. It was not self-defense. Now we're going to look at their insanity defense raised by the defense, which the defense has the burden of proving by a preponderance of the evidence.
Remember, Mr. Belinkus said it. This is the defendant's burden. The judge will tell you this. Mr. Bennett and I, the state bears no burden of proving or disproving that he was insane at the time of the shootings. That's his defense.
Right.
Even though that was the case, Dr. Schlesinger testified, and I'll talk about him in a moment. But with respect to the defense of insanity, I think it's important to focus in, number one, on the existence of a mental defect. Because the judge is going to tell you that the defendant has to be laboring under a defect of reason from disease of the mind. Now, all the doctors agree that the defendant has depression, he has anxiety, he perhaps has personality disorder, but also agree that none of those mental disorders would affect a person's ability to appreciate the nature and quality of their acts or to appreciate that what they were doing was wrong. So when you're deliberating, the testimony about the defect of reason relates to that diagnosis of delusional disorder only, which means that if you don't believe that the defendant can convince you that he has delusional disorder, then you should reject the defense of insanity.
Just because Paul mentioned it in the chat, I'll remind you all once again, we have a series of free webinars we're running through this month and next month. We're calling these our hard to convict webinars. They're 100% free. They're just under 2 hours in length, and we engage in a bunch of self-defense law myth busting myths that are commonly believed about when you're allowed to use force in defense of yourself, your family, your property, that if believed and followed are simply a high-speed interstate to prison. These things do not represent actual use of force law. They're generally contrary to the law. They make you easy to convict if you believe these self-defense law myths. We don't want you to be easy to convict. We want you to be hard to convict. And part of our mission to transform you from easy to convict to hard to convict is through these free webinars. Now, they are 100% free. We don't charge a penny, but they are limited to 100 people each. And that's so I can adequately handle the live Q&A part of the webinar. So if you're interested, and as they fill up, the dates come off the sign-up page. So those are the ones you don't see are the ones that are already full. So if you go to the sign-up page at lawofselfdefense.com/hard to convict, whatever dates are there, still have seats available the moment you're looking at it, but they might not in an hour or two or the next day for sure. These webinars fill up extremely fast. 100% free, but only 100 seats. So if you're interested, please only sign up for one. If you're interested, sign up at lawofselfdefense.com/hard to convict. And I believe our next one is Saturday, this coming Saturday. And then there's more looking forward. I don't know if Saturday still has seats available, but if not, pick a later date that's listed on that page, assuming any of the dates are still left. All right, folks, sorry about that. Promotional pause, back to the closing of the state in the Michael Barisone trial.
And to prove this defense to you, he called 2 doctors. And Mr. Belinkis called them, I forget what I wrote down, your recollection controls, said that they were both highly qualified, highly decorated doctors. You also heard that they relied on false information. They relied on inaccurate information, incomplete information. You look at experts the same way that you do with lay witnesses, police officers. You evaluate whether you think they testified with the intent to deceive you. And I start there because the defense called Dr. Hassan. Did you think that Dr. Hassan was forthcoming with his answers? Did he seem to be somebody who wanted to say what he wanted to say, regardless of what the question was asking for? I'll suggest that some of his manner of testimony was directly related to the fact that he's not as credentialed as the other doctors. You heard about Dr. Simon, Dr. Schlesinger. They both testified for both the defense and the state. They both held positions with various organizations. They've published, they're board certified. Dr. Hassan has done none of those things. Do you recall Dr. Hassan's testimony about the DSM? The DSM.
It's a big gas tank on my motorcycle, content of character. It's about 7.5 gallons.
That's not me. That's Dr. Simmering and Dr. Schlesinger both testified. This is how you make a diagnosis. It's in its 5th edition. And I asked Dr. Hassan about feigned amnesia. He said, I didn't diagnose feigned amnesia. I diagnosed dissociative amnesia. Feigned amnesia is not a term that appears in the DSM. That's incredible. That's incredible because then you watched as we read together, not from some footnote in the back of the book, not buried on some page related to something unrelated to dissociative amnesia, the page that talks about dissociative amnesia, the same diagnosis.
Judge, I hate to object, that's not in evidence, and he showed it to the jury.
He's referring to, it was referred to during the testimony of a number of expert witnesses, so it's fair game. It's not obviously going in as a piece of evidence, but it's fair game to comment on by the state. Go ahead, Mr. Shaw.
Thank you, Your Honor. The same diagnosis that Dr. Hassan told you, he gave to the defendant. And then we turned 2 pages, part of that same section, part of that same diagnosis, where it says feigned amnesia is more common in individuals with legal problems. The words feigned amnesia are not only in the book, they talk about the same diagnosis he gave to the defendant. Feigned amnesia, faking amnesia.
Yeah, that hurts.
It got worse. Do you remember what he said then? He said they must have made a mistake. The American Psychiatric Association, in publishing the DSM-5, the 5th edition of this book, they made a mistake. Dr. Hassan doesn't make mistakes. The American Psychiatric Association makes mistakes. Then I asked him about all the things he left out of his report. All the things that he testified to that didn't show up in his report. For example, what about when the defendant first obtained that gun from Ruth Cox? It wasn't that he just obtained it that day, the day of the shooting. He had gotten it from her several days before. He asked her for it. She gave it to him and she never saw it again. It was unloaded. Surely that could have some bearing on the doctor's diagnosis. And he said, well, I did discuss that with him. It's not in his report. And then he said, I didn't think that was important. He said, I ruled out faking amnesia. I gave him a diagnosis of dissociative amnesia. I gave him a diagnosis of delusional disorder. But when he first obtained the gun that he used to shoot 2 people, That has no bearing whatsoever on my report or my opinion. The last thing I'll mention about Dr. Hassan is about the tests. And again, it's your recollection that controls about whether or not the scoring system that he used to score these tests, whether that was valid or invalid. But the fact remains that whether he used a valid test scoring system or an invalid scoring system, he left the results out of his report. He ignored results from the tests he gave when they didn't fit his diagnosis.
That's not science.
Results like possibility of defendant malingering or malingering is likely. Those were results of tests that he gave to the defendant, that he came in and testified about what a great test giver he is, how experienced he is. And yet when the results didn't fit with the diagnosis that he was hired to give, he didn't include them in his report. Judge Taylor is going to tell you as part of that insanity instruction that even the most terrible crimes are committed under the influence of an impulse that overcomes the restraint that ordinarily prevents a person from committing a criminal act. What does that mean? It means that even the most terrible crimes are committed under an emotion, without time to stop and think, and just committed under the influence of that emotion, even though the person ordinarily wouldn't have committed the criminal act. Michael Barisone obviously had restraint on July 31st. He didn't shoot anybody. August 1st, he didn't shoot anybody. August 3rd, 5th, the other days he called the police. He didn't shoot anybody, but he shot 2 people, shot at another person on August 7th. And yet, Dr. Hassan gives a test to the defendant and ignores a result that says impulsiveness, ignores a result that says chooses not to keep or control his emotions in check. He gave the defendant tests that showed that the defendant could have acted impulsively, could have acted under the influence of those emotions, and he didn't put any of it into his report. Why? I would suggest it's because he wanted to deceive you. He was hired by the defendant to give a certain opinion. Was Dr. Schlesinger is a hired gun? How was Dr. Hassan any different? Now, Dr. Simring is different. Dr. Simring has obviously testified. You did hear him. He's testified on behalf of defense attorneys, on behalf of prosecutors. He testified or was retained by my office many years ago at some point. But an expert's opinion is no better than the facts on which it's based. His opinion is no stronger than the facts that he has. Imagine a person needs to go to a doctor. It's not in the criminal context, but has to go to a doctor and researches the doctor and tries to find a doctor who's very qualified, has great credentials. Everybody raves about this doctor and how great they are. And so the person goes to see that doctor, goes in, sees the doctor, and the doctor says, nope, no, too much, take too much time. I don't want to hear it. I don't need to hear it. Here's your diagnosis. That's basically what Dr. Simring did in this case. How many times did you hear him say to me, counselor, I'm not going to read all the discovery. Counselor, there's too much discovery to look at. He looked at the things that Michael Barisone gave him.
Well, I mean, it's a fair criticism in one sense, but it's also become increasingly common in many prosecutions for the state to simply overwhelm the defense with discovery, which the defense team generally doesn't have the resources to thoroughly check. I mean, going all the way back to the George Zimmerman case, the prosecution engaged what I would characterize as outright misconduct that should have resulted in some of those prosecutors being disbarred, if not subject to legal liability. They provided the defense there with a mountain of discovery, photos, text messages, all kinds of stuff burned onto a DVD. And then, as the normal practice is, they provided a summary report, a printed summary report saying on this DVD are these things. And so the defense attorneys get this. They don't review thousands of items on the DVD. They scan through the summary report to see if there's anything interesting they need to look at. And the prosecution had deliberately left off that summary report exculpatory evidence for George Zimmerman. And when they were caught, they said, well, it's not like we hid it. We provided it. It was on the DVD. We just didn't include it in the summary report. But we gave it to you. All you had to do was look at 15,000 individual items on the DVD and you would have found it. I'd suggest that is misconduct. So here there was, 18,000 pages of discovery provided to the defense psychiatric expert. I don't know any expert that would look at 18,000 pages of things, but with the arguable exception perhaps of me. I do look, when I consult on a case, I look at everything. But that makes my consultation extremely expensive. No two ways about it.
Looked at the things that Michael Barisone told him were important. And then he came up with a diagnosis just based on that limited amount of information. His report makes that clear, and I hope that it was clear to all of you. I was not pointing out all the inaccuracies or all the errors to embarrass the doctor. That was not my intention. The reason I pointed those out was to point out all the places where he made incorrect assumptions, all the places where his report was inaccurate. Do you remember we talked about he doesn't listen to statements? Dr. Simmering said, I'm not going to listen to all the statements. That would take me too much time. So what did he do? He relied on the police officers' reports where they summarized what they thought the statement said. And then we pointed out his summary of the police officer's summary was inaccurate. He was summarizing the summary differently than it was summarized. I know that's hard to follow, but the takeaway is that he was putting things into his summary that didn't come from the statement. He was putting things in his summary that came from things the defendant told him, things that weren't true.
And that's why, folks, when I do a legal consult, I look at the actual evidence myself, every bit of it that's available. I don't rely on other people's representations of the evidence because they could be lying, or to give them the benefit of the doubt, they could simply be mistaken or not seeing things that are legally relevant. Unless I look it up myself, I can't know the actual nature of that evidence, which is why I look in every case I consult on at everything.
You heard the DCP&P caseworker. She testified that she was there not to investigate a sexual abuse claim. She was there to investigate a child abuse or a neglect claim. That's what she testified to. She wasn't even cross-examined. And yet then Dr. Simmering.
In terms, I see someone in the comments, what do I charge? Well, until this year, our minimal retainer was $10,000. That's where it started. And then it went up from there, depending on the complexity of the case. So when I say expensive, I'm not kidding. Ironically, effective 2022, our real cost is zero for a legal consult. And if that sounds shocking, the reason is because we only provide legal consults to our Platinum Protection Program members. So I get letters like this every week from people wanting a legal consult for their self-defense law cases. And we say no because they weren't members of the Platinum program at the time they were involved in their use of force event. We don't take incoming inquiries, requests for legal consults anymore. It got to be too many, folks, and it's not the best use of my time, frankly. When I consult on a case, I'm helping that one client a lot, but it's one client, and it takes up an enormous amount of my time. When I do something just like this, just a live stream on YouTube, I'm reaching ultimately thousands of people will watch this. And I'm helping all of them learn about use of force law, how the criminal justice system actually works. I can just leverage my expertise across far more people than doing an individual consult. So we don't accept individual consults anymore. If you're involved in a use of force event and you'd like our legal consult, you need to have been a Platinum Protection Program member at the time of the event. If you're interested in that, you can point your browser to lawofselfdefense.com/platinum to learn about becoming a Platinum Protection Program member.
Takes the defendant saying they were there to investigate sexual abuse.
And to be clear, the reason I say the cost is zero is because if you are a Platinum Protection Program member, we don't charge you a retainer. Our legal consult is covered by you being a member. So there is no $10,000 plus retainer that you need to pay. It's just you get the consult at no additional cost.
And he puts that into his report, and he relies on that, even though it's wrong. It got worse. It got worse just because he was talking about social media posts. Mr. Belinkis made a big deal about these social media posts. Do you remember when Lauren Canarac was cross-examined about some of her social media posts? Mr. Belinkis pulled out a bunch of different social media posts and he said, "Didn't you post this? Look out, world, here I come." And she said, "Yeah, that's from a musical. That's from The Greatest Showman. It's song lyrics." And then we went through the day she was posting that. She was listening to a Meatloaf song. And then she was posting about some other type of song after that. And yet these are the posts that are supposedly driving Michael Barisone to this delusion of fear. Mr. Belinkis cross-examines her on this post about the guns. This horrible, frightening, terrifying post where Lauren Canarac says, "Yes, I do own guns." You remember what he left out? Do you remember on cross-examination when Lauren Canarac read the rest of this post where it said, they're both in North Carolina? That part was left out on direct cross-examination. We had to clean that up after Mr. Bolinkis questioned her because he left that part of the post out. And then this is the same post that's apparently given by the defendant to Dr. Simmering where he says, look, doc, she's posting about guns. I was frightened. I was in a kill or be killed situation. Then I asked the doctor, well, doctor, he gave you that post. He said he relied on that post. He was terrified of Lauren Kennerak because she posted that she had guns. Did you listen to the 911 calls? Yes. Did you listen to the 911 call on July 31st where the defendant is asked, have any guns or weapons been mentioned or threatened? His answer on the call, no. The doctor said he was aware of that. On August 1st, the defendant calls 911. Are any weapons mentioned or threatened? No.
And that's why the police could not help him. That's why when he called the police, they were of no assistance to him because there was not an actual crime or threat of an actual crime taking place. It was a civil matter.
The doctor was aware of that call. On August 3rd, the defendant calls 911. Are any weapons mentioned or threatened? Not that I've heard a word of. The doctor was aware of that. And then on August 5th.
Another question from Execution. Lots of good questions. He asked, Branca, would you have represented Barisone if you saw his case? Well, not unless he was a Platinum Protection Program member, because we don't do non-members anymore. If he were a Platinum Protection Program member, yes, he would have gotten our legal consult. Absolutely. Unlike, all the self-defense insurance programs, whether it's CCW Safe, USCCA, Armed Citizen Legal Defense Network, Law Shield, they all have conditions and exclusions for their coverage that they offer. So you could be a member of those organizations and your use of force falls within an exclusion and they don't cover you. We have no conditions and exclusions at Law Self-Defense. If you're a Platinum Protection Program member, you get our legal consult. I don't care what the circumstances were. I don't care if you were drunk at the time. I don't care if it was a domestic violence situation. I don't care about any of that. You get our legal consult, period. And by the way, you get it not just for your trial, but for any retrials, any appeals, and throughout the entire process from beginning to end. No additional cost for our legal consult if you're a Platinum Protection Program member.
The defendant calls 911. Were any weapons threatened or mentioned? His answer, not so far. The doctor said that he knew about all of those calls. The week leading up when this delusion has supposedly crippled the defendant into the fetal position, where he believes on August 7th, the only thing he can do is take a gun and try to kill Lauren Kennerak because of this delusion. And yet when he's calling 911, he's not saying a word about any of these threatening posts about firearms. And then he tells the doctor, this is what drove my delusion of fear. But perhaps the most troubling thing that came up when Dr. Simmering testified was when he was shown a series of what were called posts, social media posts. And he said, yes, these are posts that Michael Barisone gave me. He said he saw these posts, he said he relied on them, and I relied on them. Do you remember on cross-examination, I asked him if he was aware that one of those posts wasn't a post at all. It was actually a private message that came from Facebook that my office turned over to the defendant in discovery. And then the defendant is giving that private message that there is no evidence he could have ever seen before the shooting. He's giving that to the doctor and saying, look what she's posting, look what this says. And then the doctor bases his opinion on that. If you believe that the doctor relied on inaccurate or false or incomplete information, you can discount his entire opinion. And I would suggest that here, neither of the doctors that the defense called are credible. For different reasons, but that their diagnosis of delusional disorder should be rejected. Now, Mr. Bolinkis talked about Dr. Schlesinger and said, Dr. Schlesinger is a hired gun. He says whatever we want him to say. He said he didn't even come in and testify why he disagrees about the delusional disorder. My recollection is that he testified to what a delusion is. A delusion is a fixed false belief that's not based in reality. And he said in his opinion, in his review of discovery, all the time he spent with the defendant, there's no evidence that the defendant was disconnected from reality. Everything that he said was connected to reality. Dr. Simmering testified a delusion is idiosyncratic. And I said, doctor, what does idiosyncratic mean? It means it's unique to this person. No one else thinks the same thing. And then Dr. Schlesinger said, well, didn't everybody have concerns and fears and find these posts that Lauren was making threatening in some way or another? You heard that testimony. That's not made up. And yet the defendant is the only one that had a delusion, or did everybody have the delusion? Doesn't make sense. The last thing that I'll say about Dr. Schlesinger is that he testified about that issue of malingered amnesia. And if you remember, he basically said malingered amnesia means that the person is faking. And both he and Dr. Simran testified. There is no memory disorder that's selective for criminal behavior. What does that mean? It means there's no memory disorder, whether in the DSM or anywhere, that a person would forget just the time when they're
can't
committing
defame
a criminal
someone in
act
closing.
until they're finished
That's
committing a criminal act. There's no memory
immunized
disorder.
conduct. You have immunity
That's
from
exactly
that.
what you have in this case. The defendant has an excellent memory of everything that Lauren Canterac did to him, of everything that he was feeling and experiencing in that week leading up to the shooting, even up to that morning when the caseworker shows up. And then he stops remembering the moment he puts his hand on a deadly weapon. He stops remembering the moment he loads that deadly weapon and goes to confront her. He stops remembering the part where he shoots her twice in the chest and tries to shoot Rob. And then he doesn't start remembering again until he's at the hospital. And the first thing that he says at the hospital, when he opens up his eyes and he's in the hospital bed and his arm is all bandaged up because it's been broken and he's all beat up, he doesn't say, where am I? What am I doing here? How did I get here? He says, they destroyed my life. I had a good life and they took it all away.
Motive.
That statement wasn't made in a vacuum. That statement was made after he supposedly doesn't remember shooting these two people. The DSM, feigned or malingered amnesia, says people will often spontaneously confess when they're faking. Was that a spontaneous confession? He didn't have time to necessarily come up with
Yeah, almost done. Less than 10 minutes now,
So he
folks.
said, it'd be way better for me. It would be so much better for me if he made up that this was in self-defense. But he didn't do that because that's not what happened. Did the defendant
By the way, folks, I see a couple questions here in the chat I'd like to address about my legal consults for Platinum members. Yes, we do civil legal consults too. So if a civil case has been filed against you in court, that would trigger your legal consult from us, as well as if you've been involved in facing criminal jeopardy for use of force. But the jeopardy needs to not merely be theoretical. You had an argument with your neighbor, you're wondering what would happen if X, Y, or Z. There needs actually to be an arrest or charges filed or something concrete for us to actually analyze. And the other thing I heard is someone mentioned, when you ask what 2 + 2 is, a mathematician says 4, and your lawyer says, what would you like it to be? One thing you should be aware of with our legal consults, it's my legal analysis. There's no guaranteed conclusion, folks. If your use of force was outside the legal boundaries, and that's what my legal analysis concludes, that's the conclusion your attorney will get from me. Now, it's attorney-client work product. Nobody has to know but you guys. But you're not buying a favorable legal consult. That's not how it works. You're buying my expertise. So you still need to have conducted yourself within the legal boundaries. If you do that, you'll get a very favorable expert report from me on your legal consult. If you didn't do that, well, that's what my legal consult's going to conclude. So it's not a get out of jail free card, folks. It's an affirmation that you did things right. If you did things right. So please make my life easy. Do things right.
know and appreciate the nature and quality of his acts? That's the other part of the insanity defense. So if you believe that the defendant has convinced you that he was delusional, that's not the end of the inquiry. You still have to decide whether that delusional disorder made it such that he didn't know the nature and quality of his acts, or that he didn't know what he was doing was wrong. And the judge is going to tell you, you do not have to rely just on the doctors for this. You can rely on your common sense. You can rely on the other evidence that you heard. What did the other evidence show? All the same things that established that the defendant wanted to kill show that he knew the nature and quality of his actions. Everything had fallen apart. The working relationship, the business relationship, the social relationship, the farm is getting shut down, police are there, town officials are coming, lawyers are sending fake eviction notices, everything is falling apart. Then I ask, from a common sense perspective, what's the trigger? What makes it on August 7th, 2019, defendant hasn't seen Lauren or Rob at all that day? What makes the delusion at that point click? Turns off his memory and makes him say, I have to go kill or be killed. This delusion of fear has now driven me to have to go and kill. It's the DCPMP caseworker showing up there. Not to say, Lauren and Bob called us and said something about you. The defendant isn't sitting in his office, doesn't look out the window and see a bird flying overhead and believe that the bird was sent to spy on him by Lauren and Rob and that he has to go kill them. He sees the caseworker there and he decides in that moment to act impulsively, to act emotionally, and to act purposely, and to go try and kill Lauren and Rob. So I would suggest the evidence shows that the defendant did not carry his burden with respect to the insanity defense. So to wrap up, the evidence in this.
So to wrap up, before he wraps up, we wrap up so we can put his wrap up in context. So it's really undisputed that the defendant shot Lauren Canarac twice in the chest, shot at Robert Goodwin. They've essentially, the defense concedes that point. They're not making these nonsensical arguments you see out there on the internet that Barisone was attacked first and shot in self-defense. There's no evidence for any of that. So that's not real. So we can forget all that. That's not in play. He shot them. The question is, did he have a justification or excuse? Well, he hasn't come up with a justification like self-defense. Self-defense is off the table because there's no evidence to support a claim of self-defense. So he's left with the excuse, I mean a legal excuse of insanity defense, which the defense has to prove by a preponderance of the evidence. And when you hear the defense argue insanity and you hear the state argue against insanity, which one do you feel has 51% or more in their favor? I don't think the defense has proven insanity by a preponderance of the evidence here. They may have bits and pieces. They may have something there. Is it a majority of the evidence supports legal insanity? I don't see it. Yeah, it's a very high threshold for insanity, and it ought to be.
This case brings us back to where I started my opening 2 weeks ago. A sprawling, picturesque 50-acre equestrian farm in Long Valley, New Jersey. A place where Lauren Canarac, who's an aspiring rider, had gone to train. And she didn't just pick this place for no reason. She picked it because of the defendant. She wanted to go there to learn and train and become a better rider. And if you remember the testimony about this picture, she said she did become a better rider. She said this picture was taken after she had just achieved, I think it was a bronze level or something of that nature. It was a big achievement for her. It was a big step along the way. Did these look like people who always hated each other, were always scared of each other? They looked pretty genuinely happy in that picture, probably because she had just accomplished something and the defendant had helped her like he had helped all those other people along the way. Now, on the afternoon of August 7th, 2019, at that farm, a DCPMP caseworker pulls onto the driveway. She pulls up the driveway. She goes past the farmhouse on the left. She goes up over the rise and pulls down into the parking lot. She parks the car in the parking lot in front of that stable and the big clubhouse, all the training arenas nearby, and she gets out and she sees a man. That man turns out to be the defendant, Michael Barisone, a great horseman, a very well-respected, highly regarded trainer, a coach and trainer who knows that respect and trust are the keys to success, who doesn't have any respect or trust anymore for his student, feels like she doesn't have any respect or trust for him anymore. He's frustrated, furious, you could say. Not frenzied, not frantic, not freaking out, but furious. Maybe seething is a better word. Frustrated, perhaps desperate, emotional. Emotions are not delusions. And he's feeling very emotional at that point in time. When the DCPMP caseworker identifies herself as being from DCPMP, he's at his breaking point. He's not delusional. He's not freaking out. He's reached his breaking point because 2 days before, his mentor, George Morris, another great horseman, had just been given a lifetime ban from equestrian competition. And in that moment, in the parking lot at his farm, he envisions the same fate for himself. He imagines that Lauren Canarac must have done this. She must have called. She must have reported him for sexual abuse. It's not what happened. That's what he imagines in the light of everything that's going on. And for doing that, she has to die. The caseworker goes inside and she meets with Mary Haskins, the mother of the children. And the defendant interrupts once, interrupts twice. On the third time, he interrupts and says, I need the office now. You have to go somewhere else. And on her way out the office, he stops her and he gives her a goodbye kiss. He says goodbye because he knows and appreciates exactly what he's about to do. He goes into the safe, he opens up the safe, and he takes out Ruth Cox's gun, and he loads the bullets in the gun, and he makes sure to take an extra magazine of bullets in his pocket with him. He purposely picks that deadly weapon at that moment because he knows and appreciates exactly what he's about to do. He goes outside, he gets into his truck, and he starts to drive. Starts to go confront Lauren and Robert. And in him going to confront his enemy, he knows and appreciates exactly what he's about to do. He parks the truck, he gets out. He intentionally stands behind a bush where no one can see his waistband, no one can see his pocket, no one can see his hands. And he says to Rob Goodwin, how can we end this without a war? He knows that he's armed with a deadly weapon. He knows there will be no war because he's about to commit murder. But he waits. He waits until his enemy, Lauren Kenrack, has stepped down off that step until she's no closer than Mr. Belinkis is to me right now. And then he hits his breaking point and reaches in and pulls out the gun and shoots her twice. And as Rob Goodwin tries to flee from him, he tries to shoot at Rob, but the gun is out of bullets. None of what I just said was driven by any sort of an emotion, delusion of fear. Everything I just said was driven by the defendant's emotional impulses. So in closing, I would ask that you not return a verdict based on any sympathy, disgust, or emotion, but that you return a verdict that's based on reason, based on facts, and based on the law. And I would suggest if you do that, you will return a just verdict of guilty. Thank you.
All right,
Thank you,
folks,
Mr.
that's
Shelmore.
it.
Ladies and gentlemen, it's about 10 after 12. My charge will take a decent amount of time. So I'm going to give you an early lunch break today. You've been sitting all morning. Come back after your lunch break at about 1:15, and I'll give you my charge then, and then we'll select the alternative jurors, and then you'll begin your deliberations. It's important now, you've heard all the evidence, you've heard the summation, but you have not heard my charge on the law. So again, I emphasize to you, please do not discuss the case with you.
Okay, folks, so I'm going to wrap that up. I'm not going to come back, I don't think, this afternoon for the instructions. We know what the instructions are. It's the attempted murder, the gun charge. He's blanket guilty of the gun charge. That's just a possession charge. So there's not much to talk about there. And in terms of the attempted murder charges, the only defense raised by the defense here in closing was the insanity defense. And we heard the argument there from both sides. And frankly, I felt that the prosecution by far had the stronger argument against insanity, where the defense has the burden of proving insanity by a preponderance of the evidence. I don't feel like they even came close, frankly. So I'm going to put up the little card here about our absolutely 100% free but limited seating, hard to convict webinars we're running over the course of April and May. We have, I think, 6 or 7 of these left, but whether they're still available depends on how many seats have already been taken. I know some of them are full already. If you go to that URL there, lawofselfdefense.com/hard to convict, please don't sign up for more than one. You're just taking a seat from someone else. Sign up only for one. If you see a date on that page, there's still seats available, but the dates will go away as those individual webinars fill up. So the earlier you go, the more choices you'll have. Again, that's at lawofselfdefense.com/hard to convict. 100% free. If anybody in the comments has attended one, because we've done a couple at this point, we have another one coming up on Saturday. If it's not full, you can sign up for that. And want to share your experience, feel free to let the rest of the crew know, the rest of the folks in the chat. All right, I'm going to take a look at the membership page, see if there's questions there I need to answer. It looks like, yeah, there's a lot of conversation, but it looks like I answered all the questions on the membership page. No one's arguing the beatdown before the shooting. There just wasn't any evidence to support that. And if there's no evidence to support it, it's not a legal argument you can rationally make. That's why there was no self-defense instruction here. The guns were not evil. The guns were just in New Jersey, which I guess in the eyes of New Jersey inherently makes them evil. It's all nonsense, of course, but that's New Jersey for you. Beautiful state, most of it. 95% of it is gorgeous, really. But unfortunately, like California and New York, it's it's infested by a malignant political cancer. Sorry to say, I have family in New Jersey, and they live in a beautiful part of the state, and it's beautiful to visit them, but certainly could never live there. Same with New York. All right, let me look at the super chats. I think I answered all of them already. Do a quick refresh. Yep, those are done. And then over at Rumble, and there's a bunch of comments, but no questions. All right, folks. So reminding you again of those 100% free hard to convict webinars. If you'd like to transform yourself from easy to convict, which is almost certainly your current state, to hard to convict, then I would encourage you to take advantage of these free webinars. They're just under 2 hours in length. We do a bunch of myth busting, explain the fundamentals of self-defense law, the actual law of self-defense, and provide you with a strategy to transform from easy to convict to hard to convict, all at lawofselfdefense.com/hard to convict. Just pick the date and time that's most convenient for you from the pull down list on that page. And in the meantime, I'll just remind all of you that if you carry a gun, so you're hard to kill, which is why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, folks, I'll be looking out for a verdict in this case, and I'll share it with all of you when it comes out, probably in a mixed show where we cover a bunch of other small use of force things in the news that I'd like to share with you, but none of which individually is worth an hour or two of time. We'll package them all together into one show. So keep your eyes open for that. Make sure you hit subscribe on YouTube and that notification bell so the system knows, or at least you have a chance of the system letting you know when we're back on. And until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.